It's all yours, Lee.
Okay, so it appears that we now have a full contingent for the board. And if all board members participating would step forward and state your name so that the other participants may recognize you. My name is Lee Levy, and I am the chairman of the Zoning Board of Appeals.
Andy Conroy, I'm the secretary of the board.
Chris Gavrilides.
Greg Brasher, calling out of my basement office here.
And Tad Diesel.
And Aileen is our zoning staff for this evening, I believe.
I am here with Tammy Maldonado, John Hayducky, and we are being supported by Jeff from.
Very good. I shall begin the meeting. Good evening and welcome to the July 16th, 2020 meeting of the Zoning Board of Appeals. We're all present and connected. Let's spend a few minutes reviewing how this meeting will be conducted. For the first 2 hours prior to 9:30 p.m., we shall hold a public hearing on the applications that you have received a notice on and that were listed in the NOROC hour for hearing. After the application is announced by me, the chairman, and read by Andy Conroy, secretary, the applicant will come forward, identify themselves, state their name and affiliation for the record, and then present the appeal or relief being sought. Please present those zoning issues that are relevant to the practical difficulties or hardship requiring this application. After you or your representative has spoken, those in favor will have the chance to be heard. After that segment, those against the application will have the opportunity to state opposition for the record. In the case of an appeal, the zoning staff will have the opportunity to present their findings. Finally, after those against the application have spoken, the applicant and only the applicant will have the opportunity to rebut and respond to the issues raised. The hearing is then closed and the next application will be called. New applications will not normally be heard after 9:30 p.m. as the board must discuss and act upon these applications. Please note that no further public input is accepted at that time. You are welcome to stay tuned in for this portion of tonight's meeting, but should you decide to leave, you may contact the zoning office tomorrow to learn about our decision. Before we proceed tonight, I must remind you that this hearing is recorded and will become a matter of permanent public record. Additionally, all information submitted to the zoning office and staff, including photographs and maps, will become part of the permanent public record and must remain with the board. The first case to be heard this evening is application 20-0618-01. Andy?
Zion Properties LLC. In parentheses, we have on our sheet Caravel Subaru. And variances for additional signage: 2 signs allowed, 3 signs proposed. Section 118.1294A1, and variance of allowed directional signage: 2 square feet allowed, 4 feet in height allowed, 15.5 square feet and 14 feet and 6 inches high proposed for service sign, section 118, 1293, 1D, located in business number 2 zone. Property located at the address of 512 through 528 Main Avenue. 5, block 22C, lots 41, 68, and to be reheard because of the need for proper notification of abutters. That's it, Lee.
Okay, I will ask the representative for Zion Properties to please step up and identify themselves.
Good evening, everyone. My name is Rick Costantini from Halloran and Sage on behalf of the applicant Zion Properties. Can you hear me okay?
Yeah.
Okay, thank you. Thank you again for hearing this tonight. First, I'd like to just reference the fact that we were before you on June 18th with the same application. For those that were here for the meeting, you might recall that we were requesting a couple sign variances. Just to be clear, the reason for the need for a rehearing was that one of the neighbors, I had gotten the address from the GIS mapping system, which did not have an updated owner of the property. So in speaking with their staff, it made sense to redo the hearing to ensure that all parties were properly noticed. In this case, they are. So I would like to, if I can, incorporate the record from that June 18th, 2020 hearing into the record for this. I'm happy to speak to you about the variances again. I'll do it very quickly because I believe most of you were here for that one. We're seeking 2 variances. First is a variance to allow an additional wall sign to the front of the building. If you recall, there is the Subaru logo, the name Garavel, and then the Subaru word mark as well. We're currently permitted to have 2. We're requesting the third to allow for safety purposes, better visibility for drivers on Main Ave, and also so that the applicant can comply with their national branding requirements that Subaru has in place. The second variance is for a larger than allowed directional sign above the service entrance. It were allowed 2 square feet and 4 feet in height. We're asking for 15.5 square feet and 14 feet 6 inches in height. The purpose of this sign is to go directly above the service entrance. Again, this one speaks to safety. It allows drivers who are coming to the property solely for service purposes to know exactly where they need to enter the property for that purpose. So again, it's a safety issue that we're trying to address. And if you have any questions, I'm happy to answer them. I don't want to belabor any of this, especially since we were here a short while ago on the same matter.
Are there any changes, modifications between the first presentation and the current presentation?
Yes, there are.
The only change is this: we had requested a third variance in the prior application, and it was the numbered address for the ground sign. We withdrew that. We actually withdrew it prior to the last hearing. So while we took some questions on it, it was not part of our application, but it is not part of this as well. It's only the 2 variances, and the requested changes are the same that we requested a month ago when it was unanimously approved.
Okay, thank you for clarifying that.
No problem.
Do we have any other questions from our board members?
None for me. Seems pretty straightforward.
I have no others. Now, seeing that there are no additional questions from the board, is there anyone else tuned in that wishes to speak in favor of this application? Hearing no comments or questions, I'll ask if there's anyone who wishes to speak against this application. Again, hearing no additional questions or comments, I will turn.
Excuse me, Lee, just for the record, the office did not receive any questions, comments, either in favor or against this application.
Okay, well, I'll turn this back to the representative for Zion Properties if they wish to make any further comments.
I have no further comments. If there's no questions from the board, I'm good.
Okay, hearing at this point, then I will declare that the hearing is closed and we will move on to the next application. Application 20-0319-02, Nicholas Margellino.
Appeal of notice of violation of non-compliant site plan. 7 Brookfield Street, Norwalk. Section 118-1410A1 and 3 and 118 1420G. It's in business zone number 2, District 5, Block 17, Lot 36. The applicant is appealing a notice of violation issued on October 29, 2018. Just as a quick point that we need to be aware of, we have been ordered to rehear this and to look at it with fresh eyes, i.e. not think about what was already discussed and decided. Fresh eyes, de novo. The zoning office received complaints beginning in early 2018 for a commercial business operating outside the scope of its approved ZBA and zoning approvals for numerous inspections of the site, upon numerous inspections of the site and research of the historical uses and documentation regarding the property. On October 29, 2018, the deputy zoning inspector issued a notice of violation for operation of a business not in compliance with the approved zoning site plan as related to a variance granted on July 20, 1972, and for operation without a certificate of zoning compliance. Analysis and finding. A complaint was first received to the Planning and Zoning Office on January 3rd, 2012, claiming improper use of a property, which the recapping, this is the process of replacing the worn out treads, the term recapping, treads on a tire, sometimes also called retreading. Business was being operated out of compliance. The initial complaint detailed the improper storage of tires on the property and operations being conducted along Brookfield Street. These activities were taking place not in compliance with the approved variances of 67, 72, and 75. Between 1967 and 72, the application for variance was received and approved several times as a result of the applicant's failure to obtaining the building permit within the required time frame. During these applications, it was stated on the record that the purpose of the rear addition was for storage of tires, so that the tires are no longer stored in front of the building, and the area in front of the building could be used for parking by the 2 to 3 employees of the business. Moving on, the applicant asserts that there has been replacement of tires ongoing in the outside of the building for the last 50 years. This activity on the site was not allowed by the site plan or any other approval. It was not allowed then and is not allowed now. It is disallowed not only because it permissibly expands the business floor area, but also because the working repair area blocks the required parking spaces. as a result of a site inspection conducted by zoning officer John Howard in June 1975 memorandum to the board. It was stated that the area in front of the building was being used for storage of tires, which was not in compliance with other approvals granted by the board. This area must be for parking of vehicles to be in compliance. This is illustrated that on that point in 1975, there was observed and documented noncompliance on the property with a previously approved site plan. At the time of the variances being granted, 67, 72, 75, the building zone regulations of the city of Norwalk contained regulations stating parking and loading spaces shall not be used for any other purpose or any other character of automobile parking as to limit the availability for automobile parking or loading herein. This regulation states that if an area is designated for parking, it cannot be used for another purpose or another characteristic of parking, which may limit that parking area to be available to be used for the parking of vehicles. If the parking spaces are being used in another manner, which would restrict or prohibit them from being accessed and used as parking spaces by those needing them, then the manner which the spaces are being used is violation of the regulations. The applicant states, Commercial Tire has changed tires outside the building because the garage bays are too small to allow most commercial vehicles inside the building. This is demonstrative that the use has changed. The applicant also states that if the applicant is precluded from doing this work in front of its building on its property, that order could force the applicant out of business. This issue is self-created. The applicant would not be forced out of the approved tire capping business, but rather the tire changing business. Replacement of tires on these vehicles is a different use from the process of recapping of tires that come delivered to the business. Replacement of tires requires more parking from the use permitted at the property and a separate permit and possibly a state of Connecticut Department of Motor Vehicles approval as well. While both uses would be permitted within the zone, business number 2, the property simply could not sustain the level of intensity of use, additional parking, traffic flow, etc. The applicant also asserts the zoning department has essentially certified zoning compliance by merely applying for and obtaining a building permit approval and obtaining a variance constitute a certificate of compliance. This is not true. There are no implicit zoning approvals. Any new use may be applied for and granted to be authorized. Lee, go ahead.
Okay, I will ask the representative for 7 Brookfield to please come forward, identify yourself.
Good evening, Mr. Chairman and members of the board. My name is Christopher Jarbo. Are you able to hear me okay?
Just
Yes.
fine.
Okay. I'm an attorney here in Norwalk with the firm of Lovejoy and Reimer PC, and I'm representing Nicholas D. Maraglino, who is also here tonight in my office. And I'll ask him to switch chairs with me in a minute so that he could introduce himself and address the board. But before we get started, I wanted to note for the record that we did submit by email a copy of the notification letter that we sent out to all the property owners abutting or across the street, together with proof of mailing. There are 2 green cards that we didn't get back yet, but we did submit the proof of mailing. Before I get into the legal issues, as I said, I'd like to introduce Nicholas Maraglino, and I'll step out of the office and he'll sit down in this spot because this is the one with the camera, and then I'll come back after he's made his remarks.
Good evening. My name is Nicholas Maraglino. I own the property and commercial tire, which is located on 7 Brookfield Street. My father started the business back in 1960. He incorporated 1962 after he purchased the property. And I've been working at the business since 1967. So I got my 52 years in. In general, what we do is we sell, replace tires. You know, we do deliveries, we do emergency repairs on vehicles. With the COVID, we were classified an essential service. We were open every day during that. And, you know, we provided a service to a great many customers in Fairfield County area. We also do some work for the city of Norwalk, the Board of Ed. We do town of Westport tires. We do a lot of the other local towns down in Westchester. And just to mention what we do, we are the only commercial tire company that's left from Bridgeport down to Greenwich and up towards Danbury. So we do provide, you know, an essential service. What we do is, you know, we change tires, we service vehicles, we take care of a lot of commercial vehicles that are in the area. We also have another location in South Windsor where we actually do the retreading of truck tires. As far as the handling of the tires outside of the building, what we do is we just stage the tires. We have a truck that comes down from the retread shop, you know, 3 times, 4 times a week, takes that away. We have a junk tire trailer up in South Windsor where the, you know, the scrap tires are put. And we also have a couple other junk tire vendors come in and take our scrap tires away. So the outside stuff is not really storage. It is mostly just staging, and we move the tires around from there. We get, you know, probably at our place, maybe 20, 25 customers a day. And, you know, it depends on, you know, how the flow goes. But, you know, sometimes we get a few more customers. Sometimes we have no customers. We currently have about 8 employees that work in Norwalk. We have a no parking area in front of our building now. So we try to make sure that no one stops, parks, you know, in that area. So that's what we do. And we do change tires out in front of the building. We have about 15, maybe 18 feet between the building and the road. So that is where, you know, most of our work is done on the big trucks. Just some history. My father took out a mortgage back in 1975 to build the addition and put some equipment in that. And, you know, as far as the zoning certificate of compliance, you know, we've looked, we haven't been able to find it. We searched the business records from the 60s and 70s, but we just cannot seem to, you know, find anything. It is true that if we are not allowed to change tires out in front of the building, we have no access to, you know, getting to the trucks. And then we are basically, you know, prohibited from doing business as we're doing it. That's all I have. Thank you. And I'll put Chris Jarbo back on.
Thank you.
Some of you may recall that we were here last year for an appeal of the notice of violation, and the board denied our appeal application at that time, and we then took an appeal to the Superior Court. By agreement with the Corporation Counsel's office, we're back tonight to represent our application. As you may recall, there were a number of exhibits and documents that were part of the record from last year. And I understand that some of the legal briefs were circulated to the board members earlier today as well. I guess I would ask that we incorporate the record from last year, just in case any of you who were around then may recall exhibits that were presented last year. I don't want to be, you know, overly repetitive and reintroduce everything, you know, while we're talking, but I think there are items in there that might be in our minds that it would be helpful to have part of the record, especially as it relates to the arguments that we're going to be remaking tonight. In particular, I wanted to make sure that the 1960 zoning regulations were part of the record, as well as a couple of the letters that were submitted in connection with the 1975 variance application, the staff memo from John Howard, and the letter from the neighbor Herman Fullen, who is at the time was the owner of the property in back of number 7 Brookfield. As you probably know, because this is an appeal of a staff decision and not a variance application, the variance standard of unusual hardship is not strictly applicable. Under state law, the ZBA has the power to hear and decide an appeal where it is alleged that there is any error in any order or requirement or decision made by the official charged with the enforcement of the regulations. And when hearing an appeal, the ZBA has the power to reverse or modify in whole or in part any order or requirement or decision that's appealed from. And the staff's action on that is not entitled to any special deference. So as was mentioned earlier by Mr. Conroy, you hear the matter de novo, anew. So when we were here last year, the board made a decision that was based essentially on the absence of a certificate of compliance, or the failure to present proof of a certificate of compliance. The board wanted to see a document that legitimizes this use, and the board denied the appeal until such time as we return with a certificate of compliance in hand, either one that we found from years ago or one that we obtained anew. And the board never decided some of the other issues that we raised in the appeal in last year's hearing. So we respectfully suggest and request tonight that the board reconsider its decision from last year and reverse itself on this one point that it decided for a couple of reasons. First, we believe that the board's decision went beyond the notice of violation. A notice of violation is what informs the recipient of the action he must take to comply. In this case, the notice of violation that was issued in October of 2018 identified 2 alleged violations. The first was an alleged violation of section 118-1410A3. And the notice stated, to wit, non-compliance with approved site plan as approved by variance, parentheses, specifically utilizing area designated as parking to conduct work on vehicles and for storage of equipment, end quote. The ZBA did not make a decision regarding this first alleged violation last year. The second alleged violation was a violation of section 118-1420G, and it said, quote, to wit, occupying land or space without a certificate of zoning compliance or in contravention of an issued certificate of zoning compliance, end quote. This general allegation, read alone, we believe was ambiguous because it had contradictory and opposing alternatives. But it was followed by this specific order directed to the plaintiff, which said, the following must be done in order to remedy the above violations. Number 1, cease the storage of equipment and the conducting of work on vehicles within the area designated as parking on the approved site plan. And 2, create defined and accessible parking spaces within the area designated by the approved site plan. So the corrective action that was stated, we believe, informs my client, the applicant, regarding the preceding statement of the violations. And it tells him that he had an approved site plan and that he needed to abide by it. It did not order him to provide documentation that the business had a certificate of compliance. So we submit that the specific corrective action should prevail over the more general and ambiguous statement of the violation. Because when one reads the second generally stated violation in light of the context provided by the specific corrective action, the most reasonable interpretation of the notice of violation is that the city was alleging that the land was being occupied in contravention of an issued certificate of zoning compliance, not that the city was taking the position, which it had never asserted before, that the business founded by my client's father never got a certificate when or since it was founded in the 1960s. So we believe it was improper for the ZBA to require more from the applicant than the notice of violation itself required. Secondly, we believe that the board should have considered the impact of the previous variances and approvals upon the question of certificate of compliance. We argued last year that the applicant's business was permissible under the light industrial zone regulations that existed and were applicable in this part of town in the 1960s. More importantly, however, there were at least 7 zoning related approvals that we know of related to this business. Number 1, there was the variance approved by the ZBA on January 5th, 1967. Shortly after that, number 2, there was a building and zone permit dated April 4 of 1967 that was signed by William Guarneri, who I believe at that time in the 1960s was both the zoning enforcement officer or zoning inspector and building inspector at the time. He held both positions for a period of time in the 1960s. Subsequently, he focused solely on the building department, and there was appointed a separate zoning inspector, John Howard. Although the building and zone permit that was issued in 1967 by the zoning officer did allow construction of an addition to the back of the building, my client's father was unable to proceed with the construction at that time due to some financing issues. Basically, he didn't get the financing in time to complete the project, and the permit expired. The third zoning related approval was the variance that was approved on January 26 of 1972 by the ZBA. And then the fourth was another variance, basically the same variance, approved July 20, 1972 by the ZBA. Fifth, there was a building and zone permit. Again, this was a combined permit form that was used both for zoning sign off and for the building department sign off. And that building and zone permit was signed August 24, 1972 by John Howard, who at that time was the zoning inspector. And it was signed September 1st, 1972 by William Guarneri, who was the building official. Sixth was the variance approved on August 25th, 1975 by the ZBA, followed thereafter by the building and zone permit that was signed on November 6th by John Howard and signed on November 7th by William Guarneri. So that was the building permit and the variance that was in effect when the building was actually constructed. As my client mentioned, his father took out a mortgage. He got his financing. He then constructed the building on the back of the building, and that addition is still there. Now, the variance that was approved in 1975, as has already been mentioned, did have a requirement at the request of Herman Fullen, the neighbor in the back, that a 6-foot cyclone fence be installed between the properties. And that the cyclone fence is basically the chain link fence, 6 foot in height, requested by Mr. Fullen so that there would be a more orderly location for the storage of tires. And that was installed as required. There's nothing, despite these 7 zoning related approvals, there's nothing in the zoning department file to indicate that any of the zoning officers at that time ever raised the issue of the certificate of zoning compliance or the absence of a certificate of zoning compliance with the ZBA or with my client's father when he applied for the variances or when he applied for the zoning permits as part of the building and zone permit form. One of the difficulties that we have trying to discuss this today is that, you know, all of this happened so long ago. It's been 50 plus years since the first zoning variance and building permit and zone permit were signed, and about 45 years since the 1975 ones. And all of those people who were involved at the time are no longer around. My client's father passed away in 2001. I would venture to guess that whoever was working in the zoning office at the time in the 60s and 70s is probably no longer there either. So it's difficult to guess the reason why that certificate of zoning compliance document is not present in the file. However, there's nothing to indicate that the zoning staff ever raised the issue or stated that there was a missing document of some sort. It's obvious that the use of the property for the commercial tire business was an integral part of all of the applications. And not only did the board approve the application for the variance 4 times, the zoning officer, whether it was Mr. Howard or Mr. Garneri at the appropriate time, also approved a building and zone permit at least 3 times. I don't know about the one from January 72. And under state law, specifically section 8-3 subparagraph F, as in Frank, of the Connecticut General Statutes, no building permit can be issued without certification by the zoning officer that the building, use, or structure is in conformity with the regulations. So we submit that these zoning permits and approvals that were issued constitute certification of compliance. However, in its decision last year, the ZBA did not make any findings of fact related to this issue. The board did not decide whether the 7 zoning related approvals recognized or allowed Mr. Maraglino to occupy the land for the commercial tire business. The board did not discuss whether its own prior variances or the staff approvals had any binding legal effect upon its present consideration of the legality of the plaintiff's or the applicant's use and occupancy of the land, or whether they had any binding legal effect equivalent to a certificate of compliance. The board did not discuss or consider the fact that the 1960 regulations actually did not have a requirement for what's called today a certificate of zoning compliance, but rather it referred to a certificate of occupancy, which was part of the building and zone permit form that was utilized in those days. In fact, the requirement at the time was that the applicant would apply for the certificate of occupancy, which is the equivalent of the today's term certificate of zoning compliance. At the same time, he applied for the building permit. And the document in the file from 1975 shows that Mr. Romano, the contractor for Mr. Maraglino's father, did fill out the application for the certificate of occupancy, also known as today the certificate of zoning compliance. However, there's no indication why the zoning staff did not sign off on that after the construction was completed, even though the regulations, in our opinion, required the zoning officer to do that as a ministerial duty once the building was completed. It was supposed to be within 10 days, the regulation said the certificate would be, shall be issued. So none of this was really considered by the ZBA last year when it made its decision. And we believe that it's something that the board should consider now as part of this rehearing. And in doing so, we believe that the board should also consider the legal doctrine of municipal estoppel and whether it applies. Now, I know that board members are not required to be lawyers, and you might not have the legal training to decide, all questions of law, but the courts generally prefer that, as many issues as possible be decided first at the local board level before it goes on to the court. So that's one of the reasons why we had asked in part of the court papers that the matter be remanded back to you for reconsideration. Now, as a general rule, even though it's been 4 or 5 decades since my client's business has been operating on this site, as a general rule, a municipality is not prevented by delay from enforcing its zoning laws. It's also a general rule that the doctrine of estoppel does not always prevent a municipality from enforcing its zoning regulations. But there are exceptions to these general rules, and we believe that under the facts of this case, the exceptions apply. And the doctrine of municipal estoppel should allow Mr. Maraglino to operate his commercial tire business on this property. One of the exceptions to the general rules is where the party who claims estoppel would be subject to substantial loss if the municipality were permitted to negate the acts of its agents. The courts have said that any claim of estoppel is predicated on proof of 2 essential elements. The party against whom estoppel is claimed must do or say something calculated or intended to induce another party to believe that certain facts exist and to act on that belief. And the other party must change its position in reliance on those facts, thereby incurring some injury. Now, when estoppel is claimed against a municipality, the proponent, in this case us, must establish first that an agent of the town induced them to believe that certain facts existed and to act on the belief, and second, that they changed their position in reliance upon those facts. The courts have also said that estoppel may be applied against zoning enforcement only with great caution, only when the resulting violation has been unjustifiably induced by an agent having authority in such matters, and only when special circumstances make it highly inequitable or oppressive to enforce the regulations. And in terms of inducement for purposes of estoppel, the courts have said that this requires a mental state which is a general intent to act rather than a special intent to mislead. It is sufficient if actions are taken with an awareness that they would be relied upon. It is not necessary to prove that the actions were intended knowingly to mislead the party who's claiming estoppel. Cases where estoppel has succeeded are ones in which town officials have acted to issue approvals when they were fully aware of the intended use to which a property or structure was to be put. For example, in one case where an applicant's building plans had been submitted to and approved by the town building inspector, who had issued zoning and building plans after examining the site and the approvals, the court said that the town and its zoning enforcement officer were stopped from taking action 1 year after completion of the construction to enforce applicable setback regulations. In another example, estoppel was found sufficient to prevent zoning enforcement, where an architect presented building plans and the town's officials approved them, and construction then occurred according to the plans. In another case, the appellate court upheld the claim of estoppel, where the property owner spoke with the zoning enforcement officer about rebuilding a pre-existing garage that had been damaged by a falling tree. The property owner wanted to obtain the requisite permits and approvals for the replacement and enlargement of the garage. The owner met with the zoning enforcement officer and discussed the project. The zoning enforcement officer issued the zoning permit. The owner then got his building permit and started construction. Then the zoning enforcement officer, at the direction of the Planning and Zoning Commission, issued a cease and desist order. The court found that the zoning enforcement officer, an agent of the town, took many actions and made many statements calculated to induce the owner to believe that he was proceeding in compliance with the zoning regulations and to act on that belief. The court stated that there's no way that the owner could have reasonably done any more than he did to learn what would be permissible for the rebuilt garage. In our case, Mr. Maraglino's father went to the ZBA 4 times to seek approval of a building addition to expand his commercial tire business. And 4 times the ZBA approved the application, and everyone knew that the garage would be used for the commercial tire business. Furthermore, the zoning office issued zoning permits 3 times that we know of for the approved building addition. And once he got his financing in place, Mr. Maraglino's father then spent a substantial sum of money to construct the addition for the building on the belief that he could use it for his commercial tire business. The 1975 building permit form stated that the estimated cost of the construction was $10,000. That's in 1975 dollars. But Mr. Maraglino also installed other equipment inside the building at that time. He took out a mortgage on the property to do this, and my client recalls that the mortgage was for $50,000 in total. Although, because of the pandemic, I haven't been able to get into the town clerk's office to confirm the exact amount of the mortgage, but there was a mortgage taken out in 1975 to complete the addition to the building. So the point is that Mr. Maraglino made significant economic investments and improvements to his property based on the ZBA approval and related staff approvals that were issued at that time. And the Maraglinos have spent 45 years since then to operate the business on this site, developing a name and clientele and goodwill, investing in the property and its upkeep, paying the mortgage, paying taxes, etc. And we believe it would be highly inequitable or oppressive for the city to say now that they cannot operate their business at this location because they cannot produce a standalone document called a Certificate of Zoning Compliance. Shifting now to the other issue in the notice of violation, which is the allegation of violations having to do with storage and parking in front of the building. We submit first that my client is not storing equipment and tires out front. And secondly, that changing tires on vehicles that are parked out front does not violate the regulations. We will admit, certainly, that tire storage has been a challenge for the company. It is the nature of the business that the inventory takes up a lot of space, and outdoor storage has always been a customary part of the business. Although today, my client's practice is to keep tires on the side and not to keep tires out front. If there are tires out front or equipment out front, it's usually there just on a transitory, very temporary basis. And my client's practice is to clean everything up and have the property out front basically vacant at the end of each business day. And the tires on the side, as my client stated, are removed on a regular basis 3 or 4 times a week the truck will take them up to the factory in South Windsor for recapping, or to be placed into the, if it's too damaged to be repaired, then it's placed in a trailer to be taken away to a disposal site. Now, getting to the discussion of activity in the front, specifically regarding use of the parking spaces. As stated, during the workday, customers are parking out front for intended purposes relating to patronizing this particular business. There could be any number of reasons why a customer is parked out front. Some customers park there and come inside and seek information about buying tires. Some customers park out front and they come inside to buy tires. Some may be there to drop off tires for repair. Some may come back again to pick up tires that have been repaired. Some are SUVs, some are pickup trucks, some are rack body trucks or dump trucks. There are some flatbed or tractor trailers that also come in because, as Mr. Maraglino stated, this is really one of the only facilities around in this part of central Fairfield County that does this kind of work. Although he does provide tires to customers offsite as well. So, for example, he services many of the local garbage companies and oil delivery companies, and oftentimes they'll deliver, my client will deliver trucks or tires to those customers at their locations. So delivery to customers is part of the business. Performing emergency roadside repairs is part of the business. Changing tires at this location has always been part of the business. Although originally there was recapping equipment inside that has been relocated to South Windsor. So presently it's more of a wholesale and storage usage with replacement of tires occurring out front. My client's been employed there since 1967. And so he's speaking with, 52, 53 years of personal knowledge about the fact that there's always been tire changing outside of the building. This is not a change in the business. That part of the business has always existed, even though the retreading is now done in South Windsor. I would like to note also for the record that under state law, changing tires on a vehicle does not constitute what the state considers to be a motor vehicle repair. So there's no approval that's required as would be for a motor vehicle repair garage or a service station. As stated before, my client's father started the business in early 1960s. He incorporated in 62. He bought the property in 63. At that time, the property was located in the light industrial zone, number 1. The 1960 regulations, which we have submitted for the record.
I think you've made those points very clear to us.
So we do not believe that changing tires outside is prohibited by the 1975 variance. The 1975 variance is the operative variance. The other ones had expired, but they were essentially the same. We'll acknowledge that. But we believe that the city is interpreting the drawing from 1972 too strictly to say that it's a site plan as we construe that term today. I mean, basically they're arguing that you can't do anything if it's not shown on the site plan. And since you didn't say that you were doing that in 72 or 75, you can't do it now. But the purpose of the drawing was to show the location of the building addition and the location of the 3 off-street parking spaces that were triggered by that building addition. The variance application was not a site plan approval. I understand that the city's goal is to have businesses accommodate all parking on site rather than utilizing street parking for customers and employees. in 2016, the traffic authority for the city changed the parking rules in order to prohibit on-street parking on my client's side of the property on Brookfield Street. This arguably improves the sightlines for vehicles that are driving down the street. And as my client said today, if customers stop out front in that area, he will go out and tell them not to park in the no parking zone or not to park on the street. I also understand that the zoning staff has received numerous complaints from one neighbor in the back off of what is called McClintock Street. It's actually not a public street. It's really right of way. But the other neighbors on Brookfield Street don't seem to have a problem with my client's business activities. There are 4 letters that we submitted last year that I wanted to have included again in the record. Letters from other neighbors on Brookfield Street and on the Post Road adjacent to this site. There was testimony from 2 people last year, Jeffrey Capek and Susan Capek, who have a business called Tanaka Capek Design Group. They're at 11 Brookfield. My client owns the property across the street at 12 Brookfield. There was a letter in the file from the owners of or occupants of 16 Brookfield, Advanced Electronic Systems LLC, and 2 letters from people at 20 Brookfield, one from GT Electric LLC and one from Triple S Incorporated. And then another letter from Sukran's Bridal Shop at 563 Westport Avenue, all very supportive of my client and the business, stating that they have not encountered problems with blocking of the street or parking on the street. In conclusion, I wanted to request that you, as I said, reverse your prior decision regarding the alleged absence of certification of compliance based on the previous approvals from the 60s and 70s. And we further request that you apply the doctrine of municipal estoppel to prevent any current requirement for a certificate of compliance based on the fact that the zoning officers essentially certified compliance when they signed off on the building and zone permit forms 3 times in the past. With regard to the activity out front, we would note that there's no definition of storage in the 1960 regulations and nothing in those regulations that strictly prohibited changing tires outside the building. So we don't believe that it violates those regulations or the 1975 variance for my client to change tires outside today while the subject vehicles are parked in front of the building. Obviously, the purpose of the parking regulations is to have space for employees and customers to park on the property and off the street. For this particular business, some of the customers are there to buy new or recap tires, and some are there to have
Explained
tires
that
replaced.
previously.
Right. So the city's position seems to be that you can't park out front and work on a patron's parked car, because that would mean that you're taking away from space that should be available for patrons to park their car. So I think it's a little circular, and I don't think it's a violation of the intent of the regulations to have customers' vehicles parked out front and to have their tires replaced while they're parked out front. They're there to patronize the building or the business, and this is one of the things that the business does. So we hope that you'll get to this issue and that you'll consider the fact that this is something that my client has been doing on the site since the beginning in the early 1960s. And we're certainly willing to answer any questions you may have. My client's still here if you do have any questions. Thank you very much for your time.
Very good, thank you. Does any board member have a question this evening?
I think I'd want some clarity from Aileen.
There-
Sorry, what was it? Someone else talking?
I know that there's people that want to speak, so if Jeff, I don't know what the process is to allow attendees to speak. They're not listed as panelists, but they do wish to speak. Is there a way you can open it up to them, or how does that work?
But
I will have
don't we
to.
have to, wait a sec, don't we have to have staff weigh in on this? And
Well, I think that's definitely necessary.
I just wanted Jeff to know and to get prepared that there are people that want to speak that are not listed as participants. They're attendees. So if there's something he needs to do while we're working, well, the rest of us are speaking.
I was just trying to get the task list laid out. So one task is for the board to ask questions for the presentation, which was difficult using Zoom, but I think we can get it done. Then the next task is to ask who's supporting and who objects. And somewhere along the line, we bring you in. I think we bring you in, the staff in right after the applicant makes his presentation. Is that not correct, Amy?
I think that's generally been our procedure.
But then Aileen doesn't get to talk again, and we do not get to ask Aileen questions. Recall?
And we're always allowed to ask Aileen questions after she presents.
Well, only pertaining to her presentation, but if, as we go on later and then discuss this, we then can ask Aileen questions. Because
Okay, we can hold Aileen comment and after the public comments.
we could, but in other words, she doesn't get to come in and out, she could in other.
Let's let's ask if there are anybody participating that wishes to speak in favor of this appeal.
But wait a minute, we skipped one. Lee, you want to, board members to be able to ask their questions.
Well, I asked that and nobody responded to me, Andy.
But I did, and you didn't hear.
Okay. Then I will return to that and say, are there any board members that wish to ask the applicant questions?
Yeah, I do.
I recognize Andy Conroy.
With respect to the parking requirement for the site, there was discussion before, and since you've incorporated what happened last time as to this time, it would seem that it was apropos to talk about it again, of using the property across the street, and that the owner was trying to acquire it so that he could have customers and employees park across the street. Has that happened? Did we lose the applicant? Apparently. Maybe we just wait a second and see if the applicant comes back.
I
We
do
didn't
not.
happen to like move them out of panelist, did we, into listener?
Okay. Do you need to move them back?
I don't see them in the list either of not of audio only.
I don't see it. I don't see them.
Should we give them a minute, see if they just lost internet?
Right. Just so it's clear, I'll keep talking and say I'm looking for the applicant to answer questions. And if they could come back online, that would be good. Anyway, we can wait a while to get his answer. What I was asking about was property across the street. There was discussion of it last time as being acquired. If it was acquired, could they have employees and customers park there? Maybe not every customer for every purpose, but generally speaking. And then the next was, when you look at the site plan that was submitted in 75, you could say it was generalized, but does that take away the need for the parking spaces? I mean, common sense tells you you need parking spaces, so you have to deal with them one way or another. And I don't think that that's been addressed. It's sort of like, don't bother us. We don't need it. Don't worry about it. And that's not adequate. There is a prohibition in the zoning code about using parking space for other than customer and or employee parking. So if you want to pop the car up on jacks and change the tires right there, then the space is not available for customers and employees. It's only available for the car being worked on, which is why I think tire places that I visit don't do that. So
All work is conducted within the building.
I've never seen anybody jack a car up in the parking lot at any other tire place. And I've been to many. I've lived here for many decades. So that's one advantage of being old.
Well, I've certainly seen it at different gas stations, right? I mean, you know, if the bays are full and they need to like fix a flat or do something, I've seen that in gas stations before, kind of plenty of times. But I'm not sure if I've seen that as part of like standard operating procedure.
Well, Greg,
Aileen, sorry, just to interrupt. Aileen, do you have Christopher's direct phone number or any other contact information that maybe we could call him? I see a number here, but it looks like just like the main office number, the 853-4400.
That's a question to Aileen.
We probably can't. Yeah, sorry, that was the Aileen. I'm assuming we can't make much progress if these guys aren't here to do a rebuttal.
I am here. John is going to do the rebuttal. I will try and send an email to Chris Jarbo and see why he's off.
See if you can get him back.
Okay.
Anyway, so those are the things I was going to talk about. And when we get him back, we can kind of go through that real quick. I didn't have any other points. I'll save the rest for when we debate this later.
Without him, we
Yeah,
can't proceed.
Say it again, Lee.
I said, without the representative, we cannot proceed with it. I
Right.
think there are far too many questions. And I don't want this to
Agreed.
go on all night.
I think we should give, my opinion, Mr. Chairman, is we give them a window of whatever time period you feel is necessary, and then we move on to the next, because we have 20 minutes, I think, to hear any new cases, and perhaps we don't hear any
No,
more.
we have actually 52 minutes.
Oh, we hear them all the way until
We
10?
hear applicants until 9:30.
I have a question just about the process in the background. Can I ask Eileen that now? I mean, whether they're here or not.
Sure. Yeah, go ahead.
I'm just curious because are we revisiting this? It was my first time 2 years ago because the court ordered the ZBA to revisit this, or this was something, because I think Chris had mentioned the corporate counsel recommending this. I'm just curious about process and background here. That's all. Why is this back at the ZBA? It was a court order?
The Superior Court of Stamford and Norwalk ordered that we rehear it.
Okay, so this had nothing to do with the city corporate counsel.
Well, the Corporation Counsel recommended it. The applicant's attorney recommended it, and then the court ordered it. Those are stipulations that they made, then the court accepted them and then ordered this. And the only thing the court added on was that it'd be heard de novo, which means with fresh eyes and ears. In other words, you don't rely on everything you did before to make your decisions. You bring in all new, the old that you want, but you have to reconsider it, not just say, okay, I figured it out last time. Same thing.
And Matt, our attorney, is here. He can confirm that if you have any questions, specific questions.
Hi, and yes, so this was returned to you via stipulation between.
Matt, I can't hear you.
Yeah, your volume's too low.
Can you hear me now? Is this better or not as good?
Yes.
Yeah,
better.
Great. Matthew Sapienza here, representing City of Norwalk Corporation Counsel. This matter is returned to you via stipulation by the Norwalk Corporation Counsel's office and the applicant's counsel. And part of the reason was in order to support the record with with a stated reason for the board's decision. And that was the stipulation was approved by the court, and that's why it's back before you. As a second matter, I actually just did reach out to Attorney Jarbo. I called the main number, and he did pick up. He apparently got kicked off, and his internet connection is out. So
Yes, I just received a text from, or a email from him as well, that he lost his office internet.
Why don't we just
We need to
patch him in through
specifically
someone's
answer,
phone?
we need to specifically answer these legal matters at this point. Because I was part of the initial, 2 years ago, the initial ZBA hearing. But is this what we're,
That's what we're discussing.
it is the case, but you're hearing it anew. And so there are no specific questions on that piece of paper that you're holding, which for the record, the piece of paper is, I believe, a copy of the stipulation that was filed with the court and approved by the court. So there's no specific questions on that stipulation that you need to answer. But again, the board is asked to redecide this matter. Again, as has been repeated here, de novo, taking light of everything, and as per the requirement of the general statutes, to state the reasons for its decision on the record.
I think at this point, you should hold the hearing open since Attorney Jarbo isn't able to continue. I know that there are other people that wish to speak that are not
Do you,
participant list.
just one alternative, Aileen, do we just want to patch him in? I mean, I could just call him on my cell phone, connect him in this, and he's on an audio in seconds. Or we could,
That's all up to
proceed the way that you're.
board. That's up to the board how you want to proceed.
Well, he could connect to the Zoom.
We
using
could
his
be
phone.
going back in circles without him as part of the meeting.
Yeah, he
And
needs
I don't think we can discuss anything without him being, in a sense, present.
Well, he can be in a sense present via phone. Doesn't have to be
I
on
have no
video, but it's
objection to
completely up
that.
to you, Mr. Chairman.
I have no objection to that. Just, we are wasting time tonight. We've been on this.
I agree. We can either move on or we can call him. Why don't you make the decision?
Let's call him.
All right. Who's got his number? Matt, you have it?
He picked up last time at his office number, which is
The 4400?
correct.
Okay. I'm going to try it right now. Hold tight.
While Greg is working on that, Jeff, have you worked out things as far as having people have the opportunity to speak?
Yeah, so I see Mark as a attendee in here twice. The option we have is just to promote him to panelist and then he can speak.
Would
I
you
can do
please-
that whenever.
would you please do that?
Sure.
Thank you.
He's in here twice, so I'm just gonna hope I pick the right one. Mark, can you hear us?
Hello?
Hello, Mark Grenier.
Yes, I'm here.
Okay, can everybody hear Mark?
Mark, this is Lee Levy, Chairman. We're
Hey,
asking
guys.
to speak.
Was he able to join? Because I do have one of the gentlemen on the phone. He did say that Christopher was able to join, but is muted right now.
Come in here, talk on the phone. Come in here.
Sorry, I don't
Hi,
see.
this is Chris.
Let's see.
Hello?
Christopher?
Yes.
I've connected you into the bridge here with everybody on it. Are you also on a different line as well?
Yeah, I'm gonna hang up on that other line then. I don't know what
Okay.
happened, Mike. I was watching and then everything froze and then I lost internet and now I can't get back in on video. But
No
I'll hang
problem.
up
I
the
don't
other
think we
line.
need video, but let's proceed once you disconnect the other line.
All right, let me hang up the other phone. Okay, I hung up the other line. Can you hang up that?
Very good. We were at the point in this hearing where I asked if there were any board members that wish to ask you any questions regarding this application.
Hey, Mark, turn off your mic.
Yes. Okay, thank you.
Anyway, go ahead, Lee.
I was saying, we were at the point in this hearing where I asked my fellow board members if they had any questions on this appeal for you.
Are we ready to rock?
I'm not getting any response.
But yeah, I'm here. I didn't know if there are board member questions for
Yes.
me. This is Chris Jarbo.
Okay, this is Andy
Sorry,
Conroy.
I get
I'm going to talk to you about parking. It was my understanding from before, which because we're incorporating everything that was talked about last time, and I want further clarification. The owner had informed us, or you for him, I don't remember which, that he was going to acquire the property across the street. And one of his purposes was to make sure he had parking for his employees as well as customer parking as appropriate. He might still have a customer park next to the building. So did that happen? And is there parking across the street?
He is a part owner of that property across the street as part of an LLC. He spent a lot of time with an engineer trying to develop a plan to construct a building on that side of the street that would accommodate larger trucks. It's unfortunately a tight lot, and turnaround area was the real difficulty that we encountered for that site across the street. He also investigated the possibility of obtaining some property from the credit union, which owns a strip of land in the back of that parcel that might have enabled him to have a drive-through building so that a turnaround area would not be required. But you know, that plan didn't succeed either. So currently there's no zoning approval for a commercial use of that property across the street. It's currently just a multifamily house, which has a yard, but there's no approval for parking across the street.
Okay. That is a bit of a problem. Here is the problem. Regardless of whether you think there's a site plan or no site plan, or whether it was approved or not approved, or what, the one thing that you can't say is it doesn't matter. It does matter that you have sufficient parking for employees and customers, and it has to be appropriate. And you can't blow off the zoning regulations just because you decide that you see it differently. I mean, you can use parking for the employees and parking for the customers as parking, not as areas where you change tires. So I am hung up on that. I'm really, the issue of whether or not you had a CO or any related document isn't something I'm concentrating on, because the haze of time has kind of gotten in the way of really having good knowledge about that. But it's certainly obvious from the photographs I've seen that there's just a mess when it comes to parking in the front of that building. Anyway, if you had any further clarifications on how you're going to remedy that, now is the time to tell me.
Well, I can't promise anything tonight, unfortunately. It's something that my client wants to try to find a solution for, but I don't have one that I could offer tonight, and I don't want to, give you any false impression about what's going to happen when I don't have anything definitive. this is a business that he'd like to pass on to his son.
Well,
So
that's not an
finding
issue.
a long-term
for us
solution.
tonight.
Well, I know, but the point is, finding a long-term solution is something that my client is interested in as well.
And we're willing to work with you, but, you know, we need more to go on. Does any other board member have a question?
Am I allowed to ask ending questions at this point?
Probably better to wait.
You can wait, but
Okay.
actually, John, this is John's case, not mine. So,
Okay.
you should direct your
Hey,
question
John.
to John.
Everybody hear me? Hopefully, it's been quiet. Normally I'm not this quiet.
Yeah, we can hear you. So I guess I'll hold my questions until I'm able to.
John, go ahead.
All right. Good evening, everybody. For those of you who don't know me, Deputy Zoning Inspector John Hayducky. Been with Planning and Zoning since 2008. Deputy Zoning Inspector since 2016. Rather than reinvent the wheel of a lot of things that were already stated, I just want to bring some things to your attention, starting with, yes, in the 70s, 1972, two variances, 1975. We had two variances that were for to put parking within the front setback for an addition that was done to this property. And also, you know, and this was something that an appeal which we heard back in January of 2019. As you know already, was brought to Connecticut Superior Court and has been remanded down to here. So again, rather than rehash everything that was already in the record prior to tonight, I'll just bring forward some new photos that I think some of you have obtained through our permits that we gave, and just to show what we exactly what we're looking at here, what the violations are for this notice. So in your packets, there's of photos. You can see there's a photo that's dated February 11th, 2019. This is a pretty straightforward example of work being done in a parking space. Obviously, if somebody wanted to park there, they would be greatly obstructed from doing so. And I'll just quickly hold it up if anybody wants to see what it kind of looks like there. The red truck from the building. Definitely not a car parked for a personal vehicle parked there to access the business. That parking space is being used for another use. And I also do want to bring to the board's attention that back in when these variances were approved in the regulations, you know, I had prepared going through all of them, but they are in packets you received. That required parking space, whether it was to be used strictly for parking and not for any other characteristic. So the board, under testimony and information given in the 70s for all those variances, stated, look, this use requires 3 parking spaces. We are going to allow them in the front. And at that time, as it is today, any parking space that is required for a use on a property must be utilized for that parking, not working on vehicles, not storage of any tools or equipment, in this case, specifically tires. I do have one more photo that I would really like, 2 more actually, I'd like to bring to your attention. This one was taken on June 12th, 2020. Another photo in your packets there. It shows a large truck parked in the front and a car up on jacks. Looks like it's getting 2 wheels done. And there's another car, another Sprinter van parked on the side in the no parking area. And it is just an utter zoo trying to get through that street because of it. And I will again, one more time, show the photo of what I am looking at here. And so not to, again, I don't want to, wash rinse everything here.
Hey, John, is that photo the one with the 4 abreast?
With the, I'm sorry, what was that?
It looks like 2 in front of the building and 1 in the street. And
No.
another something next to it.
Yeah, and then there's another truck across the street. That looks like that. And it is dated June 12th, 2020.
Got it.
Now, just also, addressing the, the claim that violations would include business from being operated at the site. The use that was permitted, which was tire recapping, which by the owner and the owner's council own admission does not go down there anymore. This is a tire replacement, tire servicing business, which frankly, that wasn't what was approved back in the 70s with these original variances. They were under the pretext of tire recapping. But even so, both uses are, whether tire recapping or tire servicing, they are allowed in the zone today. They would just need an approval to do so. What he's precluded from doing is something other than tire recapping. That would be the thing we wouldn't allow at this point. But I do need to stress as well that that it's not so much we're here saying that whether the use is allowed or not. It's the fact that we have an approved plan from 1972, 2 separate applications from 1975, which was the most recent, stating that there has to be parking spaces for the use in front of the building. And with what goes on the property currently and has gone on in the past, that's not what is happening. And that's what we are, that's what the violation is about. And because of this, I have one last photo, if I may. This is actually taken today, July 16th, 2020. You guys do not have this in your packet because it was just taken early this afternoon. I have it here. I will present it so you can all see it and it will be part of the record. So this was approximately 11:45 this morning. And as you can tell, there is a car being worked on in the front in a parking area. And there's also equipment and tires in the front. Now, on top of that, as I was going up the hill to turn around, I noticed behind me this stopping in front of the business. So if there was not a car being worked on in the front, and if there was a vehicle parked where it was supposed to be not being worked on, anything of that nature, in theory, that truck could pull in and make its delivery and do its business. If you're trying to access Brookfield Street from McClintock, you can't see where you're coming from. That is a safety hazard, and that is also something that could be, we do have to take into account here. I'm not, again, I just have to stress again, this is strictly whether a notice of violation was issued in error or improperly. They're appealing a decision, which in this case, the deputy zoning officer made. Again, not stopping him from doing business. We are trying to get compliance with a site plan that was associated with the variance, in fact, several variances, which the zoning board of appeals approved. And if I may, just to counter some points made by the owner of the property and by the owner's counsel. In the minutes, which again, I believe you have in your packets from the zoning board of appeals meeting in July 1972, the owner at the time clearly states that the parking would be for 2 or 3 employees. There is now 8. So even that has now created a situation where there is, it's more intense than what was approved back in 1972. That's another reason we wouldn't be able to, even if we had a request to issue a CO from the property owner, a certificate of zoning compliance, which can be requested at any time after the construction is completed, that we would not be able to, in good faith, in good conscience, issue a certificate of zoning compliance when not only are the parking spaces not being utilized as they should, and they're also not in existence. They're not striped or separated or anything like that. And also this has expanded. More employees. At one time, work was done inside the garage, and if we want to say, even if you wanted to say that the work that's going on outside, for some reason was okay, well, that's an expansion of the active floor area. So therefore, more parking would be required. Therefore, I couldn't issue a certificate of zoning compliance. Again, those two are if it was requested today. And just want to make sure I get everything. The claim that a zoning approval or a zoning permit it is equal to a certificate of zoning compliance is just not. A certificate of zoning compliance is arranged by the owner of the property when construction, or the applicant for a project, when the project is completed, for an inspection to be conducted by the zoning inspector, the zoning officer, to verify compliance with what was proposed on the application. If that was the case, then every zoning permit that we issue, people can just get the permit and it's implied that it complies. So then people would just go out and do whatever they like because it's on this permit. Oh, it's certified, it's okay. There's a certificate of zoning compliance is therefore presumed. That's again not the case. Just to hash home that again, we're not talking about the use that's going on in the building. We are talking about the whether that particular notice that was issued in 2018 did an error or not. And by in the case presented that spaces, they're used, the parking spaces are used for the business, and therefore work should be allowed to be done on them. That's not, the idea is a parking space is to be clearly and definitively used for the simply parking of vehicles, not any work that's being done, even if it's only on occasion. If we allowed that, then Town Fair Tire, AutoZone, you name it, would be doing work outside in their parking spaces to earn a few extra bucks to change batteries or change windshield.
That does go on, by the way, at AutoZone.
And Lee, I'll be completely honest, if I got a complaint about it, I would have to go after them. There's a section in the regs, and I do have a lot on my plate, but I would go after them.
Okay.
So Now, like I said, I don't want to rehash 45 minutes worth of testimony and what we took in last year. If anybody has any questions, feel free. I have a wealth of information if needed.
John, I just have one question.
Sure thing, Chris.
Would you say that they've been changing tires in that manner for the last 40 or 50 years? That lot?
I would say
that generally it's been a mix of parking and changing tires in that manner for the last 40 or 50 years.
I mean, that would, to say that has been going on, I would say it has, because I think by their own admission that they have said that they do work on the exterior. And however, as was brought up by the owner's council, there was a note from the zoning enforcement officer at the time, John Howard. It looks like this in your packets if you want to take a quick look. He stated that the area in front of the building in the previous applications, this memo to the board was done prior to the last application in 1975, to highlight that at that moment where the parking should be, there was storage of tires at that time. So something else was going on in those spaces. And apparently it was to the point of where the zoning inspector at the time felt the need and felt compelled to mention that to the board.
So if I could ask a question, because I'm interested, this is Tad Diesel.
Hey, Dad.
I'm interested in when parking is parking and when parking is not parking. And you said the several pictures that you showed had pictures of cars that were clearly in front of this business having their tires changed. But one could conclude that they're parking in front of this business in order for the business to change their tires. In the same way that if I went to the Sonic restaurant and wanted a hamburger, and a waiter came out and delivered my hamburger, and I ate the hamburger, just because I'm eating the hamburger wouldn't mean that I'm not parked at the Sonic restaurant, doing the business that Sonic restaurant is in the business of doing. And so maybe you can explain for me, when does parking stop being parking?
Good question there, Tad. Thank you for making me hungry.
But
in the example given there, of Sonic, the parking space is dedicated for the use of, it's a parking space that's required for that use. So in this case, the use of these parking spaces is for the requirement of a place for employees to park. That was the stipulation that was put in that was actually asked for by the applicant. And therefore, anything else that goes on, just based on that, is against what was precluded to the board to issue those, to issue the okay for those 3 parking spaces. Now, in general, it strictly says that our regulations state that a parking space cannot be used for anything other than parking.
Yes.
So here, this is now servicing a vehicle, not the parking of a vehicle. So therefore, it's considered now we have a separate definition for that use, servicing of motor vehicles. Eating a sandwich isn't a use in our regulations. We have a lot of regs, not that one. So it's something we just don't, we wouldn't regulate. There's no separate use for in a parking space for that particular example. But we do have a use for servicing of motor vehicles. So that would change everything. That would change the use of what's going on in that space and an expansion of use going on the parcel.
Any other questions of John?
Yeah, John, I have a question. Greg here. Good to see you in person here, sort of. In order for them to get a certificate of zoning compliance, what is necessary? We said right now, like, you have to become compliant. What actually has to happen at that property?
At this property, what would have to happen is that the 3 parking spaces would have to be placed as in that permit on that site plan. I apologize, on that site plan that was granted in the variances. And those are parallel spaces, so they would have to meet the definition of a parallel parking space, which is 7 by 22, 7 feet wide by 22. They would have to be clearly marked and accessible. And also, any other space that is that's not utilized for the parking spaces would have to then become landscaping, because that creates a whole other violation if we leave that. And then, you know, we would have to verify that there is no storage of any tools, tires, anything like that in those spaces. And, you know, it may, you know, and we go by, we do our inspection after all the work is completed, you know, and then if everything is as that site plan says, they could theoretically get a certificate of zoning compliance.
So are those 3 parking spaces, are they required to be in the front?
Yes, because the zoning board of appeals stated such. Normally, in normal circumstances, Greg, this would not be allowed. It can only be done as per the board's requirement, or if they were asked of it, granting. This is parking within the front setback. It's a whole other violation. Something like this could only be granted by the board.
Okay, so you're saying, just so I'm clear, like, if would they be able to move those spaces to the side if they wanted to?
They would have to ask permission of the board. They would have to apply for another variance to do so, or they could amend an existing approved variance. They could not do that.
Okay. And so you mentioned before that, sorry, let me just go through this line of questioning here so I can crystallize my thoughts, if you don't mind. You said that they are allowed to be like a tire recapping company in this particular zone. And so let's say that, okay, let's say they cleared up to 3 parking spaces. You mentioned some landscaping, which I'll ask you more about in a minute, but are you saying that they can't have any tools, any tires, anything outside of that building like they have today?
Correct. Yeah, that is not allowed, and you cannot have storage of any automotive or any, you know, tires, tools, jacks, anything like that. That's another. I think you could safely say there's plenty of instances where that does happen, and that is a violation. You can't have outdoor storage of these things. But in this particular case, they would all have to be cleared out.
All right. So all right, I got that. Thank you. If they were to get this certificate of zoning back in 1970 or whenever it was, would that have still been a requirement?
Back then,
that you know of?
Yes. As far as I am aware, all the way back to basically when the definitions of and the inclusion of auto repair, automotive uses, never allowed outdoor storage. Again, the zoning board at any time, there could be specific situations where an application was made to the board to allow a motor vehicle use and outdoor storage. But that would be the exception.
Because I guess what I'm trying to do is understand, like, if they went through everything a while back ago, and they went through the zoning completion or got the certificate, like, did these rules change over time where all of a sudden, like, before they were allowed to have all the stuff outside and now they're not? Because it seems like there's a bunch of things here going on. I think the core of it is around like, can they be compliant with the space and how they run their business today? And I'm just trying to see, like, have we changed things on them? So like, yeah, before it would have been compliant, but now all of a sudden it's not. And should we recognize that?
Well, whatever regulations were in effect at that time, outside of the requirements of any specific conditions or requirements set forth by the board, would have to be adhered to. So if, I'm going to use as this as a quick example. If they, for example, if back then they allowed more signage than we do today. This is just an example. If they allowed more signage today, back then than they do today, and that was presented to the board at the time during that application, they could keep that. So back then, if the regulations, we'd go through, and if there's something in there that said, hey, you can have a stack of tires outside. I don't believe so. I haven't dug that deep into it. But if it said, hey, you can have a stack of tires, okay, then that's allowed. Because that's what was the regulation at the time of the issuance of the approval.
Okay. All right. Those are my questions.
Can I just add something that Greg asked? Because I had asked, I think, the similar question 2 years ago. They can't actually take those parking spots and move it to the side because they don't have the space. That's correct. Is that correct?
Well,
in theory they could, but there's no space there, so they can't.
There is no space. They physically could not do it. Just because of the way that you see on some of the maps, some of the old surveys, they don't have a lot of room on each side of the building. It gets into a right of ways and just the adjacent properties. If there was a way to get a space or two somewhere on the property, it would not be compliant with today's regulations, so they would need relief from the board.
So they lose those spaces, they lose their business. Essentially.
But they would have to, again, they just could not be doing, again, they couldn't be doing work outside in these parking spaces. They do have a bay that they can get into there, and, just looking at how this was approved, that would be my, again, one thing I will admit, this was 50 years ago. The work may have been done inside that building. You can do that still. And there's other remedies which we have talked about, which again would get beyond what we're going to talk about here, what we're addressing, but there are remedies that can be done. They would just need to be explored. Again, this isn't the case of, is this allowed? Are they put them out of business? No, we're not trying to do that. That's not what we're doing here. We're upholding what the board required, granted many years ago, but that's what was required, and we're trying to enforce that.
Well, it appears to me, and it might be the way you're looking at it also, that their business has grown to the point where it's grown to the extent they have more employees, they've taken on more work, they're not able to service all their customers within the four walls of the building.
Yes, I would agree with that. I don't think anybody would deny that their business isn't they're not doing good business, or they're a very solid business in the community, and they're doing great work. And I'm not here debating that. In fact, I would agree with anybody who made that claim.
Do we know where those 8 employees park their cars?
That would be a good question for the owner and the.
I will ask that when he comes back on. Any other board member have questions? John? Well, hearing none, do we have anyone in our audience that wishes to speak in favor of this application?
There was one letter in support from the credit union that's on the corner.
I did see that.
Did
Can
you
we
want to
have that entered into the record?
Yes.
I don't have it, so if we have to read it, you have to read it, Amy.
Okay, let me find it.
Oline, would you like me to read it in? I have it in front of me.
Yes, I'd appreciate that. Thank you.
This was received to the Planning and Zoning Office on Monday, July 13th, 2020 at 4:55 p.m. This is from the President and CEO of Mutual Security Credit Union, name Henry Baum. And the letter reads, Dear ZBA Commissioners, I am the President, CEO of Mutual Security Credit Union located at 541 Westport Avenue, directly adjacent to Commercial Tire and Recapping Company. Please be advised, Mutual Security Credit Union has no issues with the way Mr. Maraglino is conducting his business as issued in the notice of violation dated October 29th, 2018. We support his appeal. Sincerely, Henry Baum.
Okay, solely noted in the record. Is there any other letters or other members of the public that wishes to speak in favor of this appeal? Hearing none, do we have any members of the public or letters that wish to speak in opposition of this appeal?
What happened to Grenier?
You know, I'm surprised that Mark is not on. I know he.
I see Mark, he has the hand up signal. Would you like to hear him?
Yes.
Yes.
Okay, go ahead, Mark.
Can you hear me now?
Speak up, Mark.
Can you hear me now?
Yes.
Yes.
I've been denied access.
You're coming through nice and clear.
Okay. Can you hear me now?
Yes.
I hear you now. Sorry, Mr. Chairman. It's been a long night. My name is Mark Grenier. I'm an attorney with the law firm of DePamplis and Valley here in Norwalk, Connecticut. We represent McClintock Partners, LLC. We are here in support of the Deputy Zoning Inspector's, Mr. Hayducky's notice of violation of October 29th, 2018. I will say that a lot of the ground has been covered by John and also various members of the Zoning Commission regarding the questions that we have or the issues that we have tonight. But I'd just like to reemphasize what's going on here. They do have a permit for use that require 3 parking spaces, and that to this day, Mr. Maraglino has refused to abide by that permit. The pictures that were submitted today within the last month in June and at the original hearing continue to show that he is doing work outside the scope of his recapping permit that he received back in 1975. And in fact, the minutes of the 1972 meeting specifically talk about how many employees were to be on the site, and it was mentioned 2 people. And the request at that time was for 3 parking spaces. There are not 3 parking spaces on the property. There needs to be 3 parking spaces, and work is not to be permitted to continue to be done by Mr. Maraglino within those 3 parking spaces. Recapping is retreading tires. This is basically grown into a full-blown service center. Mr. Levy made a great comment that yes, they've possibly outgrown their facility. But that doesn't obviate the problem that the fact that there is a zoning approval via variance for this particular use. And to the extent that Mr. Hayducky has said if they needed to come back in and change the use, they would have to comply with the current zoning regulations. They don't comply with the current zoning regulations, and the cease and desist and notice of violation is pretty clear. Stop doing work within the area designated parking. The photographic evidence is clear. Also, to create the accessible parking in accordance with the regulations. That's what needs to be done here. I know you have a long evening, but we fully support Deputy Zoning Inspector John Hayducky in these efforts. He's been vigilant in showing the numerous time over violations. All we're asking is that the applicant abide by the zoning regulations and by the permit that was issued by the zoning commission. Thank you.
Thank you. Is there anyone else that wishes to speak in support of this appeal?
I see Tad Diesel with his hand up signal. I'm not sure if was an error.
No, I got my question answered. Thank you.
Okay. Does the representative for 7 Brookfield wish to speak in rebuttal?
Yes, thank you, Mr. Chairman. It's Chris Jarbo again.
Yes,
I
Chris.
hope everyone can hear me okay.
Yes.
So there have been a number of questions raised tonight that I think go to the heart of the issue, or the issues. One question asked by Mr. Diesel is sort of along the lines of something that I had been thinking of, throughout this matter, which is, when is parking out front not parking? If you're parked there as a patron of the business to do what the business does, why is that not allowed parking? The city's position seems to be that, well, you're taking away the possibility for other people to park there, but there's room for 3 spaces out front. If the spaces needed to be delineated more specifically and adhered to more specifically, that can be done. But I don't think that working on a parked patron's vehicle is a violation. Although the number of employees was certainly mentioned and asked by the zoning board members back in 72 and 75, I don't think that the parking out front was specifically intended to be solely for employees. It's for employees and patrons. Currently, the employees park down the street because they know that they want to keep this available for patrons. And one other point regarding equipment outside, I just don't think it's a violation of the regulations to say that if a delivery truck drops off some tires and they're on the ground for a few minutes before they move them inside, that's illegal storage. I mean, they're not there on a permanent basis. There's no definition of storage that existed that we're in violation of. So I don't think that storage of tires or equipment out front is occurring, or that what's occurring constitutes illegal storage. Also, another question raised by several people is whether we can't just come in and get a certificate of zoning compliance. And I think it's pretty clear from the comments made by Mr. Hayducky that, we probably couldn't get approved now. That's part of the fear here, is that if we came in now, he would say, well, now you have 8 employees. You used to have only 2. You don't have enough parking for your use. I don't see how in good conscience we could give you a certificate of zoning compliance. When if someone had called and he says it was the owner's obligation to call for an inspection after the building back in 1975. I don't know whether that was the process back then. I know it's the process today, but I don't know what the process was in 1975. If someone had done that, though, in 1975, and if the building was constructed where it was supposed to be, they would have issued a certificate of zoning compliance. And what we'd be talking about today is whether there's, we'd still be talking about whether parking is illegal, but we wouldn't be talking about whether they have a certificate of zoning compliance. And, to come in now and have all these new requirements about landscaping and other things applied under the current usage, I think is improper. I mean, there's a general principle of zoning that when you come into a property and you're allowed as a baby elephant, the city can't complain when the elephant is full grown. Now, yes, we're certainly much busier than we used to be back in the 1970s, and we have more employees than we had in the 1970s. But we believe that the business was allowed in the 1970s, and you can't make it illegal now simply because they have grown, or simply because they relocated the retreading equipment to South Windsor. They always changed tires. I mean, Mr. Maraglino's father was a salesman for General Tire, and selling tires was part of the business. It was always part of the business. So it's not really a change in use. It's a refocus now on something that had always been done.
Well, I'd like to make a couple of points that you've brought up. In my mind, actually, I think tire recapping is a more intensive use than tires and maintenance on wheels and tires. It involves a whole lot of toxic chemicals and a whole lot of work. But the fact is that when you're working on a vehicle out on the street or in a undesignated parking space, you're intensifying the use of your business by not being able to do that work within the confines of the service bays. The other thing is, I mean, in terms of where your employees are parking, well, you know, they're parking on property, be it private or public property, that is not associated with the business. And I am sure that there are many businesses throughout Norwalk that would love to be able to have 5 employees park within walking distance of the business. And I mean, this is an unfair utilization of property that is not owned by the business.
I don't know if I'm allowed to comment on that or not.
Of course, this is part of your rebuttal.
Well, I mean, it's just the nature of properties in general. Not all properties in town have the required number of parking spaces today that would be, sufficient to serve all of their current employees or patrons. But if it was legal before to operate the business, I don't think it can be made illegal simply because we have more employees today.
Okay.
I have a question for him, if I may. So, you talked about the. It seems to me, based on what I've heard and what I've read, that the variances that were given, many moons back, include things about, I believe, work and parking spaces, et cetera. So, how come you were never compliant to that? Meaning that it seems like these are things that are part of the variance, like you have to have these spaces. And and correct me if I'm wrong, John, but I don't know if there's anything in there specifically about equipment outside, but it seems like you're almost never compliant with the space. So when you say that we're making you, like kind of changing the rules on you, it seems like we gave you some guidelines years ago and you haven't followed those guidelines at all. So why would we give them to you now? So can you, correct me if I'm wrong, but can you share a little bit on that thought there? Because it seems like there's some requirements that the business is supposed to meet and it's not doing it today.
Well, one aspect of John's notice of violation in terms of the corrective actions that were required was that the spaces be specifically delineated out front. And we're certainly willing to do that so that it's more clear where the 3 spaces are and where the vehicles are supposed to park. But I think that's a separate question of whether a vehicle of a patron that's properly parked within the designated area, can have a tire changed while it's there to patronize the business. we're certainly willing to restripe the area out front to make it much more clear where the parking is to be and where it's not to be.
Mm-hmm. So I guess that's a fair response. John, and let me ask you a question. What is preventing any of our businesses in town that own a retail store that have parking out front just to simply say, let's just move our retail business or grocery business into the parking spaces and set up shop there? Like, is everybody in town permitted to do that? And
No.
are they doing something completely different?
They are not
Sorry, go
allowed
ahead.
to do that. That's expanding their active customer area, and our parking calculations are based on active customer area. So unless they have additional spaces, they cannot expand into a parking space. Is that clear?
Okay. And so this same thing of like selling groceries in the parking spot or selling clothing in the parking spot is the same thing as repairing tires in the parking spot or doing automotive work in the designated parking spots, correct?
Yes.
If I may, I think
Okay.
I can help Greg out here. What thorn to my side lately is Lowe's. They put stock of everything from plants to sheds to wheelbarrows to shovels, you name it, in parking spaces that are required for their location on Connecticut Avenue. Neighbors complain once a year, it's always in the summer, that they are just expanding all over the place. And what ends up happening is, because people in busy times can't find the parking spaces that were normally there, they end up parking on the nearby streets, and needless to say, neighborhood's not too happy about that. That's an example of where retail space has expanded into parking area, and they shouldn't have.
Okay. All right.
If I
I don't
may
have any further
comment
questions.
briefly on that point, I think this is distinguishable. Someone selling groceries in a parking spot is factually distinguishable from the situation we have, where we actually do have a vehicle parked. We're not using something for other than parking. We're working on a parked car, so we're not using the parking spaces to display tires for sale, for example.
At the time these cars are being repaired on the street, are all the work bays being utilized?
I believe that the work base for this building, the building's only basically one story, and it was never large enough to accommodate the bigger commercial vehicles.
But the photographs we saw presented by John show SUVs and cars being worked on, not flatbeds or stake trucks or box trucks. So these are vehicles that would fit within a standard service bay.
Yeah, I think the smaller vehicles could fit inside in the bays. The taller vehicles would not, and never did.
Are there any further questions?
Not for me.
Well,
Can I remind the board that before you start deliberating, if you have any questions for staff, you need to ask now because it's an appeal.
okay, well, I'll let board members chime in at this point if there are questions of staff.
Yeah, just one clarifying factor. John, can you just give me a quick bullet point list if you have it in front of you of the prior variances that were approved and what were the requirements of the space? Clearly you said one of them is the 3 parking spaces, but was there anything else on we'll give you this variance as long as you don't do this or do that?
To be honest there, Greg, no, I got the list of the variances here. The variances which were granted in 1972, both in January and in July, and the June 1975 approval, they just stated that the parking spaces must be in the front and they must be provided, accessibly provided. Sorry. There's no other requirement, nothing saying that they have to be, that there have to be any, they didn't put measurements. I'll be honest, they didn't put measurements on the parking spaces. That's something clearly we would do today. And if if the plan shows what appears to be 3 parallel spaces, we would have to use the standard definition of a parallel space. But that shows you the information that was approved or lack thereof, to be honest. But yeah, there was nothing.
Okay.
Fact that 3 had.
And the storage of tools and such, that's just part of the zoning for that neighborhood?
It's for any automotive use. No automotive repair can have outdoor storage. I could go into a list of I won't waste anybody's time. I have about a dozen of this situation where there's outdoor storage at automobile uses, auto repair uses. It's not permitted. So I made that point.
Okay.
John,
and what was the thing about, God, sorry, just the last one. The landscaping piece that you mentioned before, that is.
Yeah, that is any portion of in the front setback that is not required access to parking or required parking, or both. Any portion of property within the front setback that's not being utilized for that has to be adequately landscaped to the satisfaction of the zoning officer. That has been in existence since the 70s. So they would have to adhere to that. So any part that is not the parking spaces or access to the parking spaces would have to be adequately landscaped.
All right, great, thank you.
Any further?
John, did you go through the court documents?
I did. I didn't have a. I'll be completely honest, didn't have a full chance to do that because I just received them today with you guys. So I do have some. I did scan through them very briefly. Didn't go over any minutia, but
yeah.
Question I'd be willing to entertain, and I'll be honest with you if I can answer it or I can't.
Well, I was looking to simplify this to satisfy what the court asked us to do. One of the things is we tend to get a field and talk about everything under the sun, but we really need to talk about what you cited them for, and that this is a hearing on that as to whether we should agree with that or disagree with it and come to a different conclusion.
Yes, and Attorney Sapenza could clarify if I'm going wrong here, but that's about it. That's what the issue is this was sent back for a rehearing tonight to say whether this the violation cited in the notice were proper. That's what it boils down to.
Yeah, and unlike some of the other zoning hearings we might have where we skip over topics, in this case, we can't skip over them. So we've got 2 things that you cited them for that we have to deal with directly.
Correct.
One had to do with the business apparently operating without a certificate of zoning compliance. And that the second issue was non-compliant with the approved site plan as approved by prior variances, where we talk about a whole bunch of aspects of that, but particularly the parking. So we've got to make those decisions and not skip all over the place and come up with 55 different solutions.
I think those are the 2 main points we've been working on.
Kinda.
Right, and that is, and like I said, Matt can clarify if I'm wrong. But yeah, that's the point while we're here. It was the stipulated agreement said that the appeal should be reheard by the board in order to basically attach a decision for the notice overall, but specifically addressing those two matters rather than bouncing around.
And if I just want to make sure everyone can hear me.
Yep.
Yep.
So
Yep.
just to clarify, so this, and again, the stipulated order just said that the matter is going to be reheard.
Hey, Matt, hold
Sure.
the mic closer to your mouth.
Sure. Okay. So the is this better?
Yes,
Yes.
much.
So
Yep.
the stipulation just said that the matter is going to be remanded to the board, and again, according with state statute, that the board will state its reasons for its decision on the record. And so the stipulation didn't quite say exactly what you have to answer, but presumably, yes, you would. This is an appeal of the citations that John issued, so you would be deciding on the citations as issued by the zoning inspector.
Yes. So could I ask a question to Tad? This regards the certificate of compliance that was never found either by the city or by the applicant. And I wonder, is there any burden that the city bears in issuing, I think, did we count 7 approvals for variances, each of which, now is where you can correct me if I'm wrong, each of which should have some documentation that relied on an original certificate of compliance.
Well, every one of the variances that were approved, the 72 variances, and the reason it got to a 1975 variance was because the other variances had expired, meaning that either a building permit was not pulled in the statute, the time limit given by the statute, or a building permit was pulled and then that one expired. So therefore we had to start all over again. So in essence, the permit that was issued in 1975 in relation to the 1975 zoning board approval, that is the permit which would require a certificate of zoning compliance. Can't hear you, Ted.
Ted, did that answer your question?
I lost my connection. So no, I didn't hear a word of the answer, I'm sorry to say.
I'll do my best to go and speed through it again there. The variances from 1972, those variances were the whole reason there's so many variances is because they expired. Either a building permit was not pulled in the time given by statute or regulation, or a building permit was pulled. However, that expired. And then once that expires, you have to go back to the board. So what we are looking at for a certificate of zoning compliance was finally the one that they granted a variance in 1975. Building permit was pulled in an adequate amount of time, and the construction was actually done. That's what we're looking at. We need a certificate of zoning compliance for.
Okay. All right, thanks. The only other question is those 8 employees parking down the street. Is that impertinent to our consideration tonight?
Well, I mean, they park, they can park in Westport. Doesn't matter to us. Those we're simply addressing the parking spaces that are supposed to be there.
Great, thank you.
Anybody else?
Are there any further questions from the board of the staff? Well, I guess I have the requirement to close the public hearing on this unless I hear an objection from a board member for further questions. Hearing none, I will close this section of the public hearing. Aileen? Aileen? Are you still with us?
I am still here.
Okay, it's 9:50, and I know we still have 2 items to go on the agenda,
Actually, 3.
actually 3. Well, at this point, I don't think we should proceed with those items and schedule them for another hearing,
Well, let me make a suggestion.
okay?
The first item, 9 Rocky Point, is very simple, very quick. It's entirely up to you, but I think that that one should
I
be.
would be willing to hear that item and that item alone.
Okay, the other 2 items, if you'd like, you can open the hearing and continue them, and then they don't have to be re-advertised.
That is what we will do, and that's why I ask you the important questions.
Okay.
Okay, we will continue on, and the next application we will entertain is 20071601. Robert Salomon, James and Susan Salomon, 9 Rocky Point. Will the representative for that application come forward?
Yes, Mr. Chairman, it's Liz Suchy of Carmody Torrance. I'm available, as is members of our team. We're ready to present as soon as the memorandum is read into the record.
Okay, very good. Mr. Secretary?
I didn't realize I was muted. Variance to enclose existing open porch on a single-family residence previously granted by variances in 96 and 97 in B residence zone. Property located at 9 Rocky Point, District 6, Block 36, lots 52. Requested applicant wants a variance for a second floor open air deck to be enclosed for habitable space. And this home was subject to previous variance and did not include this as a finished interior space. Variances for the dwelling were granted in 96 and 97. The request to enclose 100 square feet of the second floor porch is a minor alteration and the footprint remains unchanged. Go ahead, Liz.
Thank you, Mr. Secretary, Mr. Chairman. Good evening, members of the ZBA. I first would like to say that I hope all of you and your families and friends are safe during this very trying time that we're all enduring, but I'm glad to see that everyone is available this evening, and I wish you all well in the upcoming months. The application before you is rather straightforward, and I would ask, if possible, that Amber Penberthy, who is with me on this matter, if she could unmute and, if possible, screen share with us the survey, and then also afterwards screen share with all of us a copy of the elevation that's part of the application to kind of help you through the process. I promise to be very brief, but here we go. The applicants are Robert James and Suzanne Solomon. They've owned the property for more than 20 years. The address, as you've indicated, 9 Rocky Point Road. It's District 6, Block 52, Lot 35. It is in a B resident zone, and it is also within the boundary of the Coastal Area Management Zone. So it is within the CAM zone with designations flood AE 15, VE 17, and X. The property is about just over 6,000 square feet, bounded by Rocky Point Road to the west and other residential properties to the north and south, and Long Island Sound to the east. There is also a walkway between this property and the property to the north that provides a greater setback than most other properties around. And that's just for your edification to understand where the property is. The property is improved with a single family dwelling that has been exists by way of variances granted in 96 and 97. And as a matter of fact, a variance in 1997, a similar concept, there was an enclosure of a front balcony to make habitable space enclosed. So the applicant before you this evening has a very straightforward request. There is a deck that faces Long Island Sound on the second floor of the property, and it is open right now. The applicant's desire to enclose that deck and make it indoor interior living space. So there would be no additions, no extension, no expansion of the existing footprint, no greater intrusions into setbacks than exist today. It would, if you grant the approval and then the various permits that are necessary to undertake this work are secured, it would create expanded bedroom space on that second floor. The reason, as indicated in Ms. Rochford's report, the reason we're before you is because the initial variances in 96 and 97 did not contemplate the closure of this nature on that second floor. So we are before you because the variances in those years were specific to a specific design, which did not include this design. As you know, the standard of review for a variance is to demonstrate a practical difficulty or unnecessary hardship, and that a request should be in harmony with the general purpose of the zoning regulations, and that you're authorized to exercise your discretion in a manner to secure public health, safety and welfare. That is set forth in section 118.14.10b. The hardships have already been established by virtue of the variances granted years ago, and we submit to you that the same hardships and the same difficulties exist today. The setback variance that was granted will not be expanded, will not be further encroaching upon neighboring properties. So we would hope that this 100 square feet to be enclosed on a second story porch, you would deem it appropriate to grant the relief spot. That's generally it. Here is on the left of the screen is the existing condition, and you'll see the porch is where that on the second floor and between those two sides of the building. And on the right of the screen would be the area enclosed in the middle of the screen in between those two ends of the building. That's all I have to say, all I have to add. My clients have been in touch with their neighbors. I don't know if any of them have shared any positive letters. I've been not made aware of any negative or any opposition. And as I should have said at the outset, we delivered the green cards received back in response to legal notices sent to abutting property owners and those directly across the street. And I delivered those green cards back to the P&Z Dropbox yesterday, and I suspect they're part of the file. If you have any questions of me or of Ms. Penberthy, we'd be happy to answer them, but it's really rather straightforward.
Any member of the board have questions posed to Ms. Suchi?
Not for me.
No, I agree. It's a very straightforward project. It adds no footprint to the building, and I don't think it's an intrusion on the architecture of the house. Any other board member have questions at this time? Okay. Is there any member of the public that wishes to speak in approval of this application? Is there any member of the public that wishes to speak in opposition of this project? Ms. Suchi, I don't think there's any need for additional comment or rebuttal on your part, seeing as the plans seem to be well accepted.
Absolutely. No further comment for me. Thank you for your time.
Okay, I will close this portion of the public hearing unless Aileen wishes to say something to me. I guess not. I will close.
Nothing to add.
Okay. The next two items on our agenda, I will open the items, but they will not be heard at this meeting. First one is 20-071602 Casena Care at Norwalk. Andy?
You're on mute.
He's on mute. Can you wake him?
Andy, you're on mute.
I don't have anything that I think we should further read on this, that you're going to close it or delay it.
Okay. Well, this item is open, and I will move on to item 0716-03, Scott and Donna Matson, for Button Ball Trail. We will,
Chairman, if I may be heard for 1 second on this.
of course.
If possible, I will work with staff to determine what the date would be for this matter to move forward, given the fact that I will likely be away next month during your hearing, and I have absolutely no idea what kind of connectivity I'll have where I am, and I wouldn't want to waste your time, waste the staff's time, or the public's time. So I will work with Ms. Rochford to determine when the next
Well,
date
if
would be.
we can schedule it before next month, get these two items off the agenda and hopefully approved, please work towards that.
I will work with staff, absolutely. Thank you.
Thank you, Ms. Sachi.
Just as a quick aside, this one is asking to go to 2 stories to 3.5 story.
Very well aware of that application, and I have looked at the drawings very carefully. We will have an interesting discussion.
I think it might be lengthy, yeah.
Yes. Okay. With that, I'll close the general public hearing, and we will discuss the 3 items on the agenda.
Mr. Chair, can I interject for 1 second?
Of course you may.
I believe that the representative for Care is here. I don't know if he wants to speak for a moment. Jay Russell is his name. Jay, did you want to?
Jay, if you wish to speak up at this point.
You have anything to say? You can work with me. We can talk tomorrow and figure out a schedule for a possible hearing when it'll be opened again.
Hi, good afternoon or good evening, everyone. I appreciate your time today. Aileen, I will absolutely work for you. I have my representative also on the call with us today, but we can make ourselves readily available for the next meeting.
Thank you for your patience tonight. I appreciate it.
Thank you, Mr. Chairman.
So shall we move to discussions?
You want to take them in reverse order?
Always in reverse order. We'll start with 20071601 9 Rocky Point Road. I have absolutely no objection to the enclosure of an existing deck. I don't think it changes the footprint of the house, and I don't think it disturbs the quality of the Victorian architecture. Any other comments?
Yeah, I'm in support of it as well.
Yeah, I have no problem with it. I'm good.
Okay. Tad?
Good.
Okay. I will make a motion that we approve this application. And I have no conditions to add to that. Someone wish to make a second?
Second.
Okay. All in favor of approval on 9 Rocky Point Road? Aye.
Aye.
Yes. Aye.
Okay, we have voted unanimously to approve the application for 9 Rocky Point Road.
Thank you, everyone. Have a nice evening. I hope it's not too late, and enjoy the.
Thank you. Thank you.
Safe drive home.
Thank you. Application 20031902, 7 Brookfield Street. Discussion?
Yeah, it could be kind of long. I think we need to really stick with the objective, which was to look at the 2 issues raised by our zoning inspector and see if we agree or disagree. Let's take the first take the first one, the certificate of zoning compliance. Issue that I have with that is we've had before on the board, which is when you have decades go by and the city doesn't seem to find a problem. I don't know if there was one or wasn't one, and I kind of think the fog of time blows away the issue. I don't think it matters.
Well, at this point, my feeling is that as these zoning variances progressed, if there had been an issue at any point on this path, the zoning officer would have brought it up. It's not something that just, flies by a zoning official. So it must have been believed that everything was, I'll use the word okay.
Well, wasn't this, I think we can't ask staff, so it's going to have to be our own knowledge.
It'll be our own.
In 1975, I think they were still COs, and COs were part building and part zoning. So when you finished your project, you were supposed to notify the building department that they should come and inspect you. I have seen that ball dropped a number of times.
Well, that's especially true when the chief building inspector was your zoning enforcement officer.
Yeah,
He's wearing two hats and got a building permit. It was finished. They got a certificate of occupancy. And to me, that says everything was okay.
Yeah. So at least my point of view on that first point is I choose myself personally not to recognize that that's a defect. So
I would agree.
We can't skip over the item. We just have to say we don't agree with it.
Correct.
Yeah, I think I'm in line with you as well. It seems like it was done in good faith, and they probably, if they didn't think they had this, they wouldn't have asked for so many other variances. They probably would have just kept their mouth shut and kept running their business. However, I think where we might have some challenges, at least where I have some challenges, is point number 2, no compliance to prior approved site plan. And I think that, in my opinion, like that's not excusable. It seems that years ago, we made it very clear on what they needed to have, and it doesn't seem like they have been, doing that. And they put those three parking spaces in front, and it's essentially an extended garage. And that doesn't make me feel great. It makes me feel like, that's what they're always going to do. And it also, their business has, in my opinion, their business has outgrown the place that they're at. And that's I'm glad they have a successful business. It seems like a wonderful business to pass down to his son, but they've outgrown it. They're too big for it. If they're going to be doing big tractor trailers and doing things like that, perhaps that's not the place for them to do it. So that's kind of my perspective on number 2.
I agree with Greg. And from my perspective, they've had a year and a half since we made our decision on the appeal. They've done, in my mind, absolutely nothing to come forward with anything that indicates an effort to comply with our disapproval of it. And that to me is that's like a slap in the face. Nobody's come in and said, well, let's work with you.
I think I heard them say they tried to work the parking situation across the street, but were unsuccessful in that effort. Well,
the parking situation across the street might help them with their employee parking, but it doesn't circumvent zoning regulations.
It doesn't circumvent the requirement for 3 marked parking spaces, and it does nothing to alleviate the situation that they're actually working out in front of the building.
Because frankly, tomorrow they go paint those spaces. and that would be technically okay for number one. It wouldn't for issue number two. It wouldn't help with number one.
No.
But and maybe we shouldn't even be talking about number three, which is like, can they even, are they allowed to be working in those spaces?
Well, I think you start looking at number two and you got to raise questions with number three.
Yeah.
But, yes, on number one. Number two, they've done nothing to work towards any compliance to our directive from a year and a half ago. So on that basis, I've got to, I got to say no to it.
Yeah, I mean, look, and I don't even know if this is within our power, but I'd be open to giving them their certificate of zoning if they had those three spaces and with the requirement of no tools, the landscaping aspect, and they can't be using those spaces as an extension of the garage.
I would agree. I would agree with you, Greg, because, I think there's this whole thing with zoning compliance has been mishandled or waylaid. It's not obviously something Aileen or especially John has any control of. I mean, nobody's on either side has come up with a piece of paper on that. So I would be inclined to give them what they require for a certificate of compliance if they come into compliance.
They comply, right?
Requirements.
Yeah,
Chris, you were here last time, right? What's your thought?
I take a different view, guys.
Go ahead, Andy.
Go ahead.
What'd you say, Andy?
I was going to say I take a different view. I think that when I keep calling it the fog of time, we don't know if there was a certificate or not.
Oh, no, I agree. We don't.
So I'm not going to offer
I
them
agree with that.
something that they could go to court and beat us over the head with. So I'm just going to take a pass on trying to hold them to that, because it could well have existed and they lost theirs and we lost ours, and it wouldn't be the first time. I mean, it has happened multiple times.
I agree.
So,
Yeah, I don't have much issue with that either. It's
but the
number
real
two.
issue there is whether they have a safe operation. They don't. And whether their operation is overtaxed because they've been so successful. And I think it has. And do they have any place you can park? And the answer is no. Because when you bring in a big truck, that's it. You've just wiped out the parking. And they do a lot of commercial. They do a lot of trucks as well as cars. So I just think it's the wrong place unless they can solve the parking issue. And I thought they were on the track to that, but apparently they're not.
Well, I agree with
If I may, when you're operating a business for 50 years in the same manner, it seems, wouldn't that be grandfathered in? First point. Second point, if your staff is parking on public lot or public parking, I mean, that happens all over town. I mean, if you go into South Norwalk, every single waiter, server, bus person is parking in public property. So, I mean, the public means anybody can park there. So that issue kind of is not important to me, because if their staff are parking in public spots, they are allowed to do that. So that's my issue. It's been 40 or 50 years of the same operation on the same property. And I don't.
Chris, I don't think it is the same operation. I think that they have been really successful, and they've multiplied the amount of tires, however you want to measure it, to be much more than what they started.
Is that, I mean, there's plenty of businesses in the whole landscape that get busier as years go on. I mean, how does that play into zoning? I mean, a Walmart could get busier over 10 years. A McDonald's could get busier over 10 years. So whether they're busy or not, really, I don't think that's within our wheelhouse.
Well, I think it is when they're unable to do repairs on smaller vehicles in the bays in which they're designated for use. They're doing the work out on the street.
Always.
And I think that constitutes a hazard. I mean, what's to prevent, a jack stand kicking out and the vehicle they're working on falls over on a car or a pedestrian? It's a hazard. If you walk into repair shops, there is always a sign, customers are not permitted in the service bays. And if they're utilizing a parking space as a service bay, I think that constitutes a public hazard.
Would you be surprised, Chris, if I called OSHA tomorrow and had them shut down? And that OSHA would actually shut them down?
I don't know. I mean, would I be surprised if OSHA shut them down for fixing a car in a spot?
Well, did you look at all those
I mean,
pictures?
I did, and like Greg mentioned earlier, that if you go around town, you'll see mechanics working on things outside here and there. So,
Well,
Chris, what is your perspective though? Like if someone is like fully operating their business in parking spots, which I think are supposed to be designated for like customer parking versus, working on customer's car. Like, do you feel like that's something that they should be allowed to do? And if we grant that exception, do we feel like it's going to set a precedent across the rest of the town? So now Town Fair is like, wow, let's just take all of our parking spots out front and double our work. And let's, be a grocery or a mini mart or a liquor store or whatever. And like, let's just take the, because in my opinion, it's the same thing. You're extending your store, your storefront, your workspace to, in my opinion, parking spots that should be designated for customers. And so I feel like it sets a bad precedent. I'm just curious, since you were on this last time, like, what's your perspective on that?
I see what you're saying, but the thing is, they've always been operating this way. And at some point, this operation is grandfathered in, I think. And just because the business grows doesn't mean things change. So that's where I stand on it. Now, if you had a business that was operating in bays, and then all of a sudden they're taking their business out, but it hasn't changed for them. They've always been operating in this manner for 50 years.
Yeah, but more and more people are complaining now about it. And I think that's the difference. So say a while back, nobody complained, and now it seems like there's a bunch of people complaining.
2 years ago, when we were at this first came up, the majority of the neighborhood, except for one gentleman, was for this business. And I think if you read through the paperwork, you'll see that. So the majority of the neighborhood, like 95% of them, came out in support of this. So that was actually my first ZBA hearing. So I don't know. Maybe now there's.
I guess it's.
No, Chris is right.
Yeah, I hear. Look, I hear you. I'm not sure what the right answer is.
The majority of the neighborhood did support it. A couple of other folks in the neighborhood are kind of bent out of shape now, and the guys up behind them, which I think is called Tucci, isn't it? Anyway, they do landscaping, they do road work, they do all kinds of construction. They have, if you look at an aerial of them, they have a very large lot, and they have to bring their vehicles down that little side street right beside them. And if at the moment they're screwing around, which they do sometimes, then you can't get past them. So, and it's a dead end, or not a dead end, but it's difficult to go the other direction on that street.
Well, I think what disturbs me to a great extent is that we gave them a mandate a year and a half ago. And other than telling us they tried to work out a parking situation, we have seen nothing to improve the operation of their business in front of the building.
Yeah, but in their defense, they presented a statement tonight that said that what they're doing in front of their building is in compliance with their understanding of what parking is.
Well,
so
Their
Well, they
understanding
we
and my
could.
understanding are different.
Right. Tad, did you buy that? Did you
Well,
agree with that statement?
Well, I asked the question about what the definition of parking is that would prevent us from thinking that a guy getting his tires changed in the parking place of the tire changing business wasn't parking.
Well, at Tad, the guy that should answer your question is Matt, our attorney, because the way the zoning code reads, it's very specific about what parking is. It says what you can't do. Go ahead.
Yes. Yeah, and I think he explained it well enough.
And I just don't, I think the applicant's attorney was trying to get us to buy into something that's just really not correct.
Yeah.
I agree with you, Andy. It's not correct. Parking space in front of the building along the street is not the place to be servicing or changing tires on a vehicle.
Yeah. And Chris's view that they've been doing it for 50 years, I don't quite agree with, because it seems that their business has grown and grown and grown and grown. And I think they got to the point where they've just outstripped the facility. And they have to make changes. Now, they may have been well on the road to changes because they talked about buying a property across the road. I think they know it. And it isn't just us. They know it too.
It's like, if we don't do something about this, like, I feel like we turn a blind eye to the other challenges. Like, you look at the aerial, there's 400 tires laying around the property. There's tools all over the place. And so it's like, if we want to go the direction of like, okay, you know what, fine, those parking spaces in the front, like you can park a tractor trailer diagonal, but still you got to have landscaping in those other areas. You have to remove all tools. You have to move all these tires all over the place and bring them up to full code. Like, I don't feel like that's too much to ask. And I realize that it'll probably have a large impact on their business, but like, I don't know. I feel like you can't have your cake and eat it too. So like, hey, give me these spots. I'm going to work at them, and I'm going to leave my tools everywhere, and I'm going to leave the tires everywhere, and I'm not going to do the landscaping. Like, I'm going to do exactly what I did, 50 years ago. I'm not sure that I don't feel like that's the right answer, just because they've been doing it. Like, we could go down the road of trying to give them their certificate, and I would like to, but there's other things beyond those two that they have to do to get it. And I just think that we should stick to what the code is of like, sure, you can get this, but this is what we need. We need this, we need this, we need this. You're no different than any of the other, 5,000 businesses that we have in town. That's my perspective.
Yeah. Last time around, anybody remember them talking about using the side of the building?
No, I really don't.
Trucks. What's happened since then is they bought two trucks.
From my understanding, I mean, the only way they can manage is from the front of the building. And I remember, because Greg asked the question today, I asked it 2 years ago, if there was some way we could work out where they could do their work elsewhere. And really there's nothing. There's nowhere they can go to fix these big rigs.
Well, they have the room to park the trucks there, which they at that time said they did not, because they had to have some equipment that was sitting out there. If you look at the photos, their trucks sit there. So they've expanded the business so much, Chris, that they're moving things around Connecticut using the trucks that they have parked next to that building, which they didn't have the last time around. At least I don't remember them being there or them talking about it. So
I mean, these trucks they're coming and going. No, I mean, it's not like they're just sitting there. They're coming, they're being worked on, and they're leaving. They're not just sitting there.
No, these are their trucks. Look at the logos on. Look at the logos on the trucks. They're doing really well, Chris, is what's happening. They're doing really well.
No, I understand that. We should be happy for that. I mean, it's just.
Well, I'm not happy they're screwing things up.
In a sense, and I don't say this to ease my conscience, because, I mean, this is a Norwalk homegrown business that is successful. But this might be kick in the seat of their pants that has them looking at other properties. And as businesses fail due to COVID-19 and the downturn of the economy, there are properties accessible to highways and such that will become available. And, you know, maybe they should make an effort to look and really seriously grow their business. But that's an opinion in the back of my mind that has no bearing on this application.
Essentially,
So do we
he
think we have
wants us
enough?
Go ahead.
Sorry,
Who's
Andy.
talking?
It was me. I was just wondering if we thought that we've had enough debate amongst the team here, if everyone has their opinion, or do you want to continue to discuss?
We can, somebody can make a motion.
I was going to ask Aileen, is there?
I don't want to make one too early, though.
I was going to ask Aileen a question about process, not about this particular thing. Can we do a 90-day stay or a 180-day stay? In other words, let's say that we decided to deny their request and we stayed any action for 6 months.
I don't know the answer.
What would
to
that
the
do?
question.
Oh.
To
Perhaps
give them time to try to weasel the hell out of the problem and see if they come up with a solution quickly.
I mean, do they only get one appeal?
Well, they could go back to court again, but I don't think they're going to win this time.
What I think Andy is asking is, I mean, we could leave this open for 60 or 90 days and request some more information from the applicant if we feel that's necessary.
Well, what information would you guys, I don't, my opinion is, I don't think there's other information that I would need. So what information would we want that would have us?
I don't know what
that we want to solve for.
I'll be honest. I have an opinion on this.
Yeah.
And, you know, I think we should deny it because I don't think that they have, you know, shown me any indication that they will comply.
I agree with you, but I think I'd like to give them, if it's legal to do so, a 6-month period in which we will hold all action off. But at the end of 6 months, if it's the same situation persisting, according to our zoning inspector, John Hayducky, then the action is taken.
I would agree with that.
Why?
But I don't know if it's legal to do that.
Can we ask Matt to chime in?
Yeah, I would love Matt chimed in. Remember, we can't hear you. Lift it up.
I believe that extensions can be granted with the consent of the applicant. However, I think we are limited to, I believe, I have to double check, it's either 35 or 65 days. I don't believe that the executive orders that have to do with COVID would allow us to, or allow the board to extend it for 6 months. I would have to double check, but I believe with the applicant's permission, it can be continued for definitely 30 days, and it might be longer, but I'd have to just
I think they can get an extension for 65 days.
65, I believe so too.
Matt, while you're still there, can we make it very specific? In other words, we want them to find a solution to the parking that we think is a problem and would ultimately not work in their favor.
You can modify, the board is allowed to modify the, and again, this is an appeal of the violations cited by the zoning inspector. And so the board will be deciding those two violations. You can issue modified orders of those violations. But eventually, yes, it will have to be a denial or acceptance, but I guess you can issue some kind of modification as
So
well.
could we do this very specifically? Could we say that we deny it with the provision that in 60 days, John Hayducky or whomever is designated will inspect again for the city of Norwalk? And if we do not see a solution at hand to the parking issue out in front of the building, that they are denied from that point forward.
I can live with that.
You can, and if
But isn't it more than the parking though?
What more?
It's also the storage of tires and tools.
Well, John could,
and where they're doing the work.
Wait 3 months and go back and hit them on that. But I mean, just to try to solve the problem and keep them in business, what they need to do is find another place to do it. But they can't do it overnight. So particularly with COVID-19.
Yeah, but us saying no, Andy. So let me just look. I don't want to put these guys out of business. I mean, I really don't. But us giving them more time, like, what does it actually do? If we say no today, does John show up tomorrow and board up the windows and they're out of business? No. So it's like,
no, they go to court.
But you know what I mean? Like, what is the point? I guess what is the point of doing that? If we say no to this, because couldn't they come back after this and ask for a different variance or exception to change the parking from the front to the side to something like that? They could still do it. I feel like there's two matters in front of us that I don't think we're in agreement on that we should say yes to. That is not preventing them to come back and say we have a different plan on how we're going to clean up the property and move our parking. And that kind of puts, that kind of ends this cycle and starts a new one.
When it went to court, each side presented their cases, and the court didn't. Yeah, I've got to say it directly. The court did not agree with us, so the city was in a position that it could lose. It wasn't clear cut. So one of the options was, well, why don't you kick it back to the city and have them rehear it in the ZBA, which is what happened. I don't think a second go through to the court is going to work very well. I think it's going to work against us. And I think that we need to be very specific that we're looking very hard to find a solution.
Well, I think we should offer them the opportunity to present to us a workable solution. I mean,
and within a short time, 60 days.
60 days.
Isn't the answer to say that we will give you your certificate of zoning if you can fix these things? And like, haven't we already said that to them? Like, hey, we'll get this to you. That's no problem. You can have this type of business in the neighborhood, but you can't have stuff out front. You have to fix the landscaping and you have to fix the parking spots. So, and then if you do that, great, you have it. We're done.
Aren't you in essence telling them that, you have to do these things, but these things are basically going to take them out of business? They can't, from my understanding, do the things that we're saying. So it's either one or the other. There's no kind of mid-road in this. Am I correct, Eileen? I mean, they can't put parking on the other side. They can't put these big rigs anywhere. So there's really nothing they can do.
They could move more of their business inside the bays, it appears to me.
They could move some of it, but not all of it. And then we might still have some of the same issues. I mean, I think we're going to end up being in the same spot. What's that?
They have to offer us solutions. We're not going to sit here, as I've done on other boards, and try to solve their problems. They need to sit down with somebody, be it a surveyor, a land planner, whatever professional they can work with, and look at the site and work out the parking, work out workspace, storage. That's their job, not ours. We're not trying to put them out of business. We want them to work better and smarter and safely. That's our goal.
Okay, Matt, do you have a way that we can put this together, that we give them the 60 days with the requirement that they develop a plan, a solution, so that ultimately we can issue them a certificate of zoning compliance for the type of business that they have?
Again, I think the board is allowed to continue its decision, especially with consent of the applicant, for 60 days. If the applicant were to solve the problem within then, to some degree, the issue might be mooted. And again, I know it's at least 35 days, and I'm looking now whether it's 65, but there's a time period where the board could hold its wait till it issues its decision. And I think it would. I think what you're saying is in the meantime, if the applicant were to somehow fix this problem, that potentially by the time the board were to come back to actually issue its decision, the whole issue potentially could be mooted or not.
I think that's what we should do.
Yeah, I know that I can't ignore it. This is just, it gets worse constantly. It doesn't get better by itself. And they've got to fix this, and I can't fix it for them, so.
Well, as John showed us, they saw the pictures from a year and a half ago, and John presented us pictures from today.
Yeah.
The situation has not gotten better.
True.
So I'm going to try to make a motion that we delay our final decision for 65 days, if that's the legal limit, and allow the applicant the opportunity to present us with a working plan of the site indicating parking spaces and legal work areas.
I'm not sure if the applicant can present additional information to the board with the continuation, but it is 65 days for the board to issue its decision, if that makes sense.
What will we have to do, Matt?
The hearing has been closed, therefore you cannot get any additional information,
Okay.
but you can take time to make your decision.
Okay, well, I make a motion, we wait to make our final decision for 65 days. That'll give us the opportunity to discuss this at the next two meetings.
The opportunity to what?
Discuss it among ourselves. That happens in really, really tough cases, but we haven't had one of those. This is getting close, though.
Yes, it's probably the second most difficult that I've encountered in my time on the board, so.
Yeah, if we can't do that, then I'm just gonna vote it down tonight. I'm not gonna go along with continuing it or having them persist, because I think they gotta solve it and not ignore it.
Well, Andy, if you would make a motion to that effect.
Well, I'm gonna bounce the motion off Matt, and if he says go, then that'll be the motion. So we have an appeal of the this zoning inspector's judgment that the certificate of compliance is not available, may not exist, and there is non-compliance with what he sees as an approved site plan approved in previous variances. Those two things, in the first instance, I'm going to say that we, the board, don't agree with it. And within the second instance, I'm going to say we, the board, do agree with it. until such time that we have fully discussed this for the next 2 months, 60 days, and reached a final decision. I don't think we can push the certificate of zoning compliance issue successfully.
Yes, and so I think, yeah, and just to summarize, I think according to the law, yes, the board has 65 days after the close of the public hearing to make its decision. So
Right.
You're not obligated to make it at this time.
So the thing I did differently, Matt, was I kind of laid out where we would be going after the 65 days, unless something caused us in our discussions to do it differently. That's being cute, but hey, there are times it's a good thing to do.
Keep in mind that you can't take in any new information. Your decision has to be based on the information that you received tonight and the other information that was incorporated into this hearing. So, and you can't talk amongst yourselves.
Well, if we can't do that, I see no reason for dragging this out for 65 days. My opinion would be, let's deny it and let them come back with another application. We deny it without prejudice, allow them to go back to court, allow them to present another application.
Can you do a denial with no prejudice with this? I don't think you can. You either agree with your zoning inspector or you don't. It's really straightforward.
I'm going to make a motion that we deny their appeal for the without zoning application and for the non-compliance to the prior approved site plan.
I'll second that.
Okay. And how are you going to deal with their certificate of zoning compliance? You have to deal with both of those.
You deal with them separately or together?
No, you can deal with them separately, but you have to deal with both of them.
Well,
I'm not sure what they're asking.
My answer to that is that there is no evidence of zoning compliance, and that if they wish to return with another application, they can work towards zoning compliance.
Yeah, I think that the city is complicit in this, and that you can't have variance after variance after variance.
Responsible.
Huh? I agree. You can't do that. You can't have one action on top of another action on top of another action, and then say that the thing never existed. It's just baloney. So I think that exposes us to looking silly. So I would say that we don't agree with the zoning inspector on the certificate of zoning compliance because we think so much time has lapsed, we just don't really know. So we're just not going to agree with it. That could be what our statement is. And then the second one, I agree. I don't approve of the site plan being ignored, and all those statements that were in prior variance discussions have been ignored for a very long time.
Yeah, Andy, I think you make a fair point about number one. 50 years is a really long time. I don't exactly know. I think it almost doesn't really make a difference to us, like saying yes or no to that, because they still have to come back and comply with all these things to get that. So unless I'm wrong, I think I'm okay with that.
Okay, I just don't want to go to court with something that is really murky. I don't mind telling you.
Yeah, no, I'm agreeing with you.
I don't know.
Well, if we can.
No, I'm agreeing with you. Still doesn't really.
All right, so that's item one. Item two, I don't like what they're doing on the site. Haven't liked it from day one, and they do need to fix it. We can't apparently come up with a good way to forestall this, so it just gets denied, and that's it. Their appeal on item two. We agree with them on item one. We disagree with them on item two.
Okay, can we find a way to put that into a motion?
Yeah, I think I kind of put it that way until we got into the discussion at the end of it. We don't need all that extra garbage in there, but.
I'll second your motion.
Aileen, do you know what the motion is, or do you want to fight back through this one more time?
Well, Greg made a motion and then Lee seconded it, and that was on that's what I'm confused.
Denial. They were denying, what they were doing is they were denying because of the non-compliance with the approved site plan.
Okay,
I interjected at that point and said that we can't really make that decision about the certificate of zoning compliance because there's so many instances that the city was involved with that.
right.
That it's too long ago. We don't know what the hell happened. Therefore, we're going to not agree with the zoning inspector on that point. We do agree with the zoning inspector on the second point of non-compliance with the approved site plan.
Okay, I think that's clear.
Okay.
Now,
And did someone second that? Lee, you second that?
I second that.
Anybody triple it? Yeah.
Okay.
Yeah. Oh,
We've got one more item.
Did we vote?
Oh, no, we didn't.
now we got to vote.
Okay. Aye.
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 We're missing who, Chris?
Wait, we're voting
Not in
on
favor?
both or just one?
just one.
And that one was that we agree with the first part, right?
Mm-hmm.
Well, then that
we
about
agree
the zoning
that-
certification.
We agree with their appeal that the certificate of zoning compliance is a non-issue, basically.
Is it not? We agree with them. Okay,
Well,
then I agree with
them,
you.
yeah, the applicant.
Yes.
But on non-compliance, we're telling them they have to comply and they didn't, therefore we're denying their appeal.
Well, then I would be nay on the second one. So is that nay for both?
No.
I
So
don't know.
it's unanimous on the first issue, correct? And then there's, I believe, Tad, I'm not sure what you said, but your vote on the second one. I know I was in favor of the, the fact that they are in favor of the right word, that they are non-compliant, that we believe that the inspector was
I
correct.
think Chris is the only one who splits. Chris is
Right, correct.
okay with the point that certificate of zoning compliance is too long ago. We don't know the hell what it is. And he's not in favor of holding their feet to the fire on non-compliance.
That's correct.
Andy, you
So we
made,
have 4 yays on that and 1 nay.
correct. Andy, you made the motion on the second part. Who seconded that motion?
I
Well,
did.
if we're going to split it, that'll be my motion. Let's split this and go with the vote that we just had of 5 in favor of 1 and 4 and 1 on the other vote for the first one.
Right, but I just wondered you made the motion, who seconded the motion?
Okay, I moved to split these 2
Mhm.
points.
Yes.
Anybody second that?
I'll second it.
All right, all in favor of the split?
Aye.
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 Chris, you in favor of it?
Split 4-1 on the second and 5-0 on the first.
Well, yeah,
Aye.
we're just saying we're going to split it so that we vote on each one separately.
Oh, yes, okay.
Two different
Aye.
votes.
Yes. Okay, so that's unanimous. And then we have the vote on the others. If anybody wants to change their vote at this time, speak up.
No.
So on the point 1, we're all in agreement. On point 2, Chris disagrees, and then we have 4 yays.
Correct.
Correct.
Okay. Moving on to something we discussed 3 hours ago. Application 2006-1801 Zion Properties.
Okay.
I don't have a different view than I had last time. I'm in favor of approving.
I'm in favor of it also.
As am I.
So all in favor?
Do we make a motion?
Aye.
Aye.
Who made the motion? We did, right?
I made the motion.
I second it. All right, all in favor?
Aye.
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 Unanimous.
Okay, do we have any other business we have to transact?
Yeah. Oh, no, wait a minute. We did it. We did the first one. Yeah, so we're done.
We're done.
Well, we have the minutes that we didn't approve. You got 3 sets.
3 sets of minutes.
Well, one of them, I wasn't at the February meeting, so I have no opinion on that. The other 2 set of minutes I went through, and I think I was fine with both of them.
Yeah, I was fine with them all.
Somebody
I'm
want
fine
to
with
make a
them all as well.
motion on the December minutes, please?
I moved the December minutes for approval.
I second that.
Yeah, before we vote on this, can I ask a question? Since I was an alternate at all of these meetings, do I have a place to vote on the minutes?
If you were an active participant,
I was present.
any part of it, yes.
Yes.
So, wait. I attended, but was not an active member. I was an alternate.
I know, but you didn't make judgments about any of the cases? And
That's right.
Like you did not vote on anything?
That's correct.
Okay. So, yeah, I would just abstain from this.
Okay, good. Thank you.
Okay, so we have the December minutes that we have.
A motion. I need a second.
Motion to be seconded.
The second was Greg. Greg did the second and the others approved.
Yep.
And Tad abstained.
Yes.
Good.
February minutes, I was not present, so I will not vote.
Anybody want to move it? I was chairing it. I'm not going to move it.
I vote to approve the February minutes. Or make a movement.
We need a second, then we're good. I'll
Second.
second. All right, no, Chris seconded. So
I'll second
all in
it.
favor?
Aye.
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 And Lee Levy abstains.
Yes.
And I abstain.
And Tad Diesel abstains.
Okay,
And
March,
June. We got June.
there was no March meeting,
Yeah, there wasn't.
June meeting.
June.
What
June.
happened to May?
I'll make a motion that we approve the June meeting minutes.
I'll second it.
All in favor?
All in favor?
Aye.
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 Tad Diesel abstains.
Abstain.
Is that the only abstention?
Yes.
Good, we're set.
We have a motion to adjourn.
We have a motion. I'll make the motion to
We do.
adjourn.
Second that.
Very good.
All in
second that.
favor? Everybody.
Aye.
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 Everyone have a great night. Have a good
Good
night.
night.
Good night,
All
everybody.
right,
Good
guys.
night.
Cheers.
Thank you, Chris.
Stay healthy.
Bye.
Yes, stay well.
Okay.
Thanks, Tad.